Besides this is obviously going to be, if you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
I think it says it's going to matter.
We, the jury, being duly impaneled and sworn, find the defendant Matheau L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
Good morning, everyone. Hello, good afternoon, good evening, wherever you are. We're having a bit of technical issues. But it's all good. It wouldn't be the same if there was no boomer technical issues, either from myself, from Matthew, or from Mighty Meat. So how are you? How are you sounding? Oh, you're here now, Mighty. Jesus. How you doing, mate?
I had an issue, so I think it should be resolved. What's up, gentlemen?
You sound perfect. What about Matt? How are you sounding? How's the sound?
You guys sound great. Coming through really good. I'm having issues with my headphones, but that's all right. No big deal.
But you can listen to your phone. We can sort that out. You're not a problem. It's fine. The main thing is we're working. That's the main thing.
Yeah, last time we talked, you were horrible. You had issues.
No, not the last time. The time before that.
Right. The time.
Last time was fine. No, because I got a new laptop now. So nice. The time before that, Mighty Meat saved the day. So. And that's not normal for Mighty Meat. Normally he ruins my day, but he saved my day that day. So
that's true. That's very true.
But thank you to Mighty Meat as well, because he's traveling at the minute. He's actually leaving Detroit, which is like, whoa.
I'm back.
I knew we wouldn't be long.
Yeah.
You wouldn't be long. Right, let's whiz through the chat here. Tully Pip. Hey, my darling, how are you? Christine, hey guys, I'm Matt's chat. So Christine's doing an interview with you tomorrow, I believe, Matt. If I'm correct in saying, is she doing something with you tomorrow? Matt's gone off, but we'll get back to that. Welcome, everyone. Sarah P's in the house. Thanks for joining. Please hit that like, subscribe, and hit that notification bell. The same rigmarole. You can join and become a member. Check out the official merch store. Please consider supporting the channel. PayPal or buy me coffee. That's the best way. Never required, but I'll always appreciate it. Stacey Q. Wrong chat, Stacey. If Stacey's still here, wrong chat. She's on about Karen Reed's chat, not this one. But actually, they all lied as well here. Yeah, so it's the same thing. Lou's in the house. Lou Hillier Psych. How are you doing, my darling? How are you doing, Lou? Hey, Stacey. Hey, Lou. Murph's Turf. How are you doing, Murphy? How are you doing, my darling? Hope you're well as well. Hope you're enjoying Karen Reed. Sarah P. Hey, Dylan, Mighty Meat. Hey, Sarah P. Ever so polite. Hi, Dylan, Matt, and chat from Lou. No hello to Mighty Meat, but he didn't deserve it, so it's all good. It's all good, Lou. I don't forgive you. So excited to make a live. Yes, it's good. Especially we got one witness, last witness, and then we got closings. So, and then what we'll do, I'm not discussing with Matt yet, but next week we'll bring Matt back for the verdict. And then let loose wherever Matt wants to cover then. So whenever we'll cover that offline.
All right. Cool.
You know, whenever suits you, to do that. Sarah P. Mighty Meat. I watched last night's stream on replay with a new Afro Man song. I laughed so hard. I don't know what that's about.
Oh, it's so great. Politics.
Well, I mean, it's obviously politics. So he's going to be stricken. You're going to be stricken at one point or another. So go watch his channel now, Mighty Meat's channel, because it's going to be stricken probably in the next 12 hours. Yeah,
dangerous misinformation. Yeah.
Hamburgers in the house. Bo gets his homie Franklin. Go Bronx. Go. Baseball Dad, how you do, fella? Baseball Dad, how we enjoying Karen Reed as well. So Baseball Dad's also watching Karen Reed. So he's been with us pretty much from the start, Matt, following your case, and now he's following Karen. So there's a lot of similarities. A lot of similarities with the bullshit that goes on in these cases.
Dirty cops.
Dirty cops. Not just dirty
Very
cops,
dirty.
a lot of dirty people, involved. Hey, baseball dad. Right. So as I say, we got going today, Matt. We got your final witness. Who have we got? Who's your final witness? Do you remember?
Yeah, let me think. It was there was a guy from OSU, a professor that they hired to see if the branch that Emily used would hold her weight. They brought him in. He did a test. The branch held, and then they never called him back. My attorneys found out about him somehow and asked him to come testify for me.
Perfect.
Boring.
It's fine. We're going to play it quickly because it is, as you say, it's going to be a little bit boring with CVs and stuff like that, obviously. But the main part, I think, is going to be closings. That's
closing. It's awesome. You're really going to
so
like it.
We'll slow it down for the closings. But we're going to play a 1.5 for the last witness. We'll play a 1.25 for the closings then. Because closings are like 3.5 hours. So, and this witness is about 2 hours. So we need to zoom through it. Right, there we are. Based with that dirty ass cops. Yeah, I mean, who would want to be a cop?
Sociopaths. Sociopaths want to be cops.
What do you mean? Yeah.
Very true. Dill.
Yes.
I was watching the Karen Reed trial, and it was funny to have everybody gushing over you. I was like, damn, they don't know this guy. Like, it was comical. So I just wanted to throw that in.
Yeah, thanks, mate.
Yeah.
You see, I'm a good host, I'll try to be,
Yeah.
UDF is in the house as well. Finally, in case we don't have to fight about. It's not fighting. It's just more of a, there's no one fighting Murphy's exaggerating. It's more the fact that different views. We come into it with innocent unless proven guilty, but not everyone always comes in looking like that. But it is what it is. Right, let's get cracking. Murph's Turf in the house as well. Right, let's get going. Let's put this in here. And we are go. Obviously, same as usual. Matt, anything you want to jump in on, just jump in. Mighty Meat, anything you want to jump in on, same for you as well. As I say, we're going to go through the next 2 hours super, super quick, and then we'll slow it down for closings. So here we go. Motherfucker. Can you even hear it? I can't even hear it.
I can't hear it.
No.
I can't hear it.
It's fine. Let me just check this now then. Yeah, it's through that. Hang on. Let me just jump on. Yeah, no, it's just the judge.
Stage suicide.
It's just the judge. It is not us. So he starts off quiet.
Here today. And I am...
No, let me go back. So...
you didn't play the part where he storms out yet.
No, I know. I'm going back. So I think the first bits starts at 16. No, it's all right. Let's go forward. So I think the first bit, he is muted. Right. But it'll kick in.
I came in this morning thinking I was going to get let go, that he was going to throw the case out. I was positive. I mean, you guys remember hearing the argument, which was before this, right?
Yeah.
I think for the Rule
Right.
29. So her argument was weak, right? Diane was really strong. So let's.
Right. So that's the start of the audio from there.
That's it.
But it's interesting you came in thinking positive like that. Was Diane positive as well?
I couldn't read her, man. No fucking.
Yeah.
I had no idea.
No, but you were positive. Yeah, I got you. Right. Let's get going.
Right now without the county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay. Okay. Your objection is noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff...
Your objection is noted. Okay.
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment. That it wouldn't be.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
I think he thought it was going to get thrown out too. So that's why he did that.
Yeah, but what a prick! Like, what a baby! Jesus
I
Christ!
guess. I guess that doesn't happen very much in court. Like you can't walk out like that.
Matt, what do you think of the judge? Quick question.
I thought he was really fair. I thought watch what he does as a reaction to this. He's good with it. He's okay. Thought he was a fair guy. He said, like, I don't know where everybody gets in, but at the end of the trial, they went back and told the jurors that he thought that this case should have never got brought to trial.
Yeah, we'll get into that.
He kind of knew. I'm a little upset that he didn't throw it out because that was my ass. But I think he just figured, you know what? Let's let the jury make the decision. So
it worked out better for the end. It did work out better in the end,
right?
As it happens. Anyway, we'll go more into the judge again, but I wanted to ask that because Lou's one of my favorites, so I have to ask that question. Lou. But obviously, loads of questions next week when Matt's back. Ask him anything you want. The books are open. Ask him anything you want. Anything you want. You can ask him. So, right, here we go.
I prepared my remarks and my decision here today, and I am, I guess, I am glad I had the opportunity to spend the night to do some deliberation on this matter and think about it. But I want to kind of begin with a sidebar before I go to the motion itself, and it's an apology I'm going to make to the defense team here. Before you made your motion, I made a few statements that were probably an effort at humor, but I think they could have been interpreted as intemperate, unnecessary, or perhaps even offensive. And that was certainly not my intention. And I likewise did not in any way try to imply that your motion was simply a matter of the record in an administrative act and perhaps without merit. And I say that not only because that wasn't my intention, but your arguments were well-spoken, compelling, well done, and very professional. And in fact, I want to say that both lawyers have been professional throughout this entire case. You're the kind of lawyers that any judge would want on his or her docket trying a case. And I want you to know that. And I regret a lack of reciprocal professionalism for that moment there, and I wanted you to know how I felt. And I wanted to share that with you.
He said something about letting her off her leash. That's what he's apologizing for. He said he made a reference to letting Diane off her leash.
And Diane was not very happy about it.
No, I don't think. I think they're that's lawyer judge bullshit. Who cares, right? Who gives a fuck? But she was insinuating that she was a bitch, right?
Yeah.
Leech dog. He obviously didn't mean that, but he's apologizing to. He's a class act. This guy's a class act, man. He's a good dude. Most judges probably wouldn't even care.
Not many people would do that. Not many people would apologize. So fair play to him. I'm so pleased you had a fair judge and a brilliant defense attorney, Matt. He did you a massive favor by not throwing it out. Yes, because there would still be questions now if you had.
He kept out evidence, and he kept evidence in. I don't really know the ins and outs of all that, but he wasn't going to let him he wasn't going to be like letting in nonsense. He didn't let in any nonsense, really. Right.
We're going to go through this in uninterrupted to start off with because we're going to fly through this bit. Unless there's anything specific you want to speak about, obviously.
I was just making sure that you knew what he was talking about right there. That's all.
No, that's fine. The testimony now coming up. More than anything. Ronnie, hello, Ronnie, my darling. Hope you're well, Ronnie. Right. And Ronnie, you haven't been here for Matt. This is Matt, the defendant in this case. He looks different, but this is Matt underneath me here. So
the court, as I said, has had an opportunity to consider this case for a significant period of time last night. And I note that in my 20 years, both as a sitting judge and a visiting judge, I have rendered decisions on Rule 29 motions in every criminal case, and I've denied those motions and I have granted those motions. But I think I can say this has been the most difficult motion for me to consider.
I'm going home.
I had time to reflect upon the arguments made by counsel. And I think probably one of the reasons it's difficult is that both the state and the defense have made very compelling and good arguments.
Oh, come on. Their case sucks.
Perhaps it's more the state of the evidence presented that I'm working with that I've had to spend a lot of time thinking about. I want to begin this decision by saying what is not a part of the court's consideration. I am not judging the credibility of any of the witnesses who have testified, nor giving weight to any of the witnesses, nor in any way whatsoever injecting my personal opinion, if any, as to what I would think the state of the evidence is. I am certainly not considering this case on the standard of beyond a reasonable doubt. As we all know, the standard is to look at the evidence in the light most favorable to the state without any of those other considerations. And the court has done so. And my job, if you will, is to determine whether or not there's evidence in which jurors could come to even different conclusions, but one which would be a decision in favor of the state. Now, I have already indicated, and I reaffirm at this point in time, that
Thanks.
There you go, Matt. That's nice, isn't it? I know who Matt is. I followed this trial and cried when he was found not guilty. I was high-fiving in the air because I was the only one in the house. There you go. That's nice, Ronnie. Thanks for saying that.
Thank you very much, Ronnie. I know it was very emotional, and I could feel it out there. I could feel people out there feeling for me. It was very emotional. I'm glad you were there for that.
There you go. Just so Ronnie know, this is like week 24, I think, or something, 25 with Matt going through this case. So that's why I wasn't sure. I haven't seen you here for this series. That's why I meant more than anything. But thanks for being here, Ronnie.
State has amply satisfied its burden in regard to the motion, in regard to the establishment of this being a homicide and a staged suicide. With that determination, following that, a vast majority, if not the great majority of the elements of murder, both purposeful murder and felony murder, as well as felonious assault, are satisfied by that finding by itself. The issue that's primarily before the court is the question of the identification of the perpetrator who has committed this homicide and staged suicide from the evidence. What probably has made this case most difficult is that there is no direct evidence establishing the defendant as the perpetrator in this case. Now, the state is not legally required to do that, but it does enhance the decision process at this time to be more circumspect. Clearly, as the state has acknowledged as well, that circumstantial evidence is the cornerstone of this case. And the inference reasonably raised from the evidence that in a natural and logical way would follow and according to the common experience of mankind as to what those inferences are drawn from direct evidence is what the court must look at. And I think consistent with the requirement that the court look at the evidence in the light most favorable to the state, the court must also look at the inferences in the light most favorable to the state. So the court has considered the circumstantial evidence provided. The state has, I believe, and perhaps a bit ironically, established the question of motive. The defendant is married to the deceased. The evidence is presented that they've had chats and messages to each other that have been classified as difficult, argumentative.
Oh, that's no excuse.
Including one not to each other, but one on May 7th, where the defendant declared that his marriage was over. Evidence that 2 weeks prior to the argument, there was testimony that there was a very loud argument in the garage. Statements made that are inconsistent with some of the facts determined by law enforcement, and misstatements or even lies made to police. And of course, evidence in regard to the argument that Mr. Moore made statements in the past tense, which inferentially is that the speaker would have known that even though the deceased was not discovered, she was not going to be discovered alive. This kind of is the evidence that demonstrates that the defendant could very well have been unhappy and angry with his wife, and the behavior after he reported her missing could circumstantially infer that he knew something that he was not telling the police. The state also presented evidence, largely through the digital forensic evaluation of
You can speak.
Which, as we all know, reflects the usage activity and non-user activity of the phones, that reflected for approximately 3.5 hours on the evening of May 24th and the morning of May 25th, that there was no activity for which time period any acts of the defendant were unaccounted for. Now, again, several inferences may be drawn from that, certainly, but the inference most favorable to the state is that he could very well have been engaged in the conduct that resulted in the demise of his wife. The argument presented by the state, based upon the evidence presented in its totality, is that, again, under the rule, the court has made the finding that this was a homicide and staged suicide from the evidence in the view most favored to the state. And the question raised from that evidence, by working from that, is who would be a perpetrator, who would take the time and necessity not only of ending the life of an individual, but taking the effort to stage it so it would appear to be a suicide. Now, we obviously know, and the evidence reflects, that within 48 hours, the police provided the Miranda rights to the defendant. So he certainly began this case as a person of interest upon whom suspicion would fall, and that's virtually the case every time when a spouse is missing or is found to be a victim of a homicide. Certainly, circumstantially, based upon that evidence, based upon the conclusion that the court's finding that this is a homicide and staged suicide, is also rather consistent with the thought that the evidence provided the fact that suicide over a significant period of time has affected the difficulty in the lives of both the defendant and his wife, which likewise has a bearing upon why that could very well have been staged by her husband. Again, at this time, considering all of this evidence and in light of what the court has preliminarily addressed regarding the nature of the court's decision, I find at this time that taken in total, the state has met its threshold burden to allow this matter to be considered by the jury, and thus the Rule 29 motion presented timely.
That's the only time I got upset. That's the only time I got upset.
The court will simply state for the record at this time, and particularly since we are coming to the close of the state's case due to our unique agreed circumstances, that the court on its own motion is going to take under advisement a Rule 29 motion at the conclusion of all of the state's presentation of evidence.
Dude, I was like...
And we'll proceed accordingly. Now, with this decision, we are now at the point where I guess we should take this opportunity, if you wish, to go over jury instructions. Are there any, is the state ready or willing to discuss jury instructions at this point?
Yes, Your Honor, I am. Thank you.
All right, what would you, what changes, deletions, additions, or corrections would you seek?
Thank you. Hold on, sorry. I actually just have a few things to point out to the court. Respectfully, Your Honor.
Dr. Hines, how we doing, mate?
Hey, doctor.
Hey, Matt. Hey,
What's up?
Dylan. Hey, Mighty Meat. I'm
What's
glad
up,
to
buddy?
See you guys again. I'm glad to see you guys again. How you doing, Dylan?
Good. I'm just putting Josie over your face. There we are. Josie is Dr. Hines.
She's an eyesore, so you're doing everybody a favor here.
Sorry, I didn't mean to do that. But yeah, I'm well. Nice to see you, buddy. Nice to see you. To see you, nice.
Yeah, you look well. You look
Thank you, man.
a lot more happier, I would say, these days. You look a lot more happier. Not that you were miserable before, but like I can see the more upbeatness coming out of you, if I
Good.
can make that observation.
No, it's fine. That's good. It's good. Well, it's I've got a new laptop. Good start. So it's
I
fine.
see. Okay,
That's
that
fine.
makes sense. That makes sense now.
No, Dr. Hines. Everybody was kissing his ass hardcore in the stream before this. That's why he's so excited.
Right, where's the
Like,
mute button?
let's not
Where's the
play.
mute button? Where's the mute button for Mighty Me? Here we go. Nah, yeah, that's been good.
What the Karen Reed?
You can read going
trial,
well,
isn't it?
Yeah,
Yeah.
it's going well.
Yep.
So
Nice.
no, it's good. So we got this witness now. We're going to zoom through this witness because it's 2 hours, I think, or an hour and a half. Then we got closings then, and then there'll be trying to get them through as well. So this bit's going to be fast, Dr. Hines, this first bit, but then after that we'll slow it back down for the closings. I've just jumped over jury instructions because I can't be asked to stream that bit. But Matt, you were saying, Matt, you were this is the first time you were upset. Was this bit?
It's the first time I really showed any emotion. I couldn't. I told myself don't, but I rolled my eyes. That was about it. But I was trying to be as stoic as I could. But it was tough. I thought
There you go.
I mean, come on, look at the situation I was in. Come on. I'm like,
No,
you're
I
kidding
got you.
me. This is going to jury? You're kidding me. I couldn't
I
believe
got
it.
you, man. I don't blame you. I got you. Right. There we are. Everyone's saying now. Josie's in the chat. So now we're safe. We can continue now. Josie's in the house. So just everyone needs to behave now. And then we can fine. Right. Let's get crack-a-lacking then. And off we go.
I do.
Good morning.
Morning.
Introduce yourself to the jury, if you could.
My name is John Bolte, and I'm a professor at Ohio State University.
Before I ask you just a few questions about that, Your Honor, at this time the parties agree that Dr. Bolte is an expert in biomechanical engineering.
That's true, no objection. Thank you.
Thank you. Somebody with the record, please.
Thank you. Dr. Bolte, you just indicated that you're a professor. Tell us about what you do at Ohio State.
I am a full professor in the School of Health and Rehab Sciences, which is within the College of Medicine at Ohio State University. I'm also the director of research for the school, and I serve as the founder and director of the Injury Biomechanics Research Center at Ohio State.
Do you have a CV?
I do.
Showing the witness what has been marked as Defendant's Exhibit SS.
I'm sorry, what was that again?
Sam.
Thank you.
Dr. Bolte, does this look familiar? Let me go to the last page. It appears to be 46 pages long.
That is familiar, yes.
And when did you provide this to me at some point since we met?
Yes, when you came to my office to meet the first time, I provided this copy to you.
And if you recall, when was that meeting?
I do not recall. I would say 2 to 3 weeks ago.
Does this appear to be a fair and accurate copy of your current CV marked as Defendant's Exhibit SS?
It is.
Tell us a little bit about how you became involved in this case with respect to Emily Noble.
I first became involved on October 26, 2020. I received an email from Detective Grubbs requesting if I knew anyone that could help test a tree to see how much mass the tree could suspend. And it was just an open email, and I responded with, I don't have a lot of expertise with the tree, but I might be able to support this.
When you say mass, what does mass mean in that context?
Weight.
And as a result of that initial outreach from Detective Grubbs, what, if anything, happened next?
We exchanged a few emails. I believe there was an email from a tree expert that had a suggestion of how to test the tree. We decided to meet on November 6th at 9 a.m. at the location so I could view the tree and brainstorm what engineering tests we could do to potentially test this tree branch. So the first meeting was there at the scene on November 6th of 2020.
If you recall, who was there at the scene on November 6th?
Detective Grubbs in Alloway, myself, Dr. Yoon-Siak Kang, who is another professor in the IBRC, along with myself and Dr. Amanda Agnew, who is also within the IBRC.
Agnew showed up again.
Was there another time that you went out to that same location?
We actually went back out on November 11th to run the tests that are in my report.
Which takes me to, did you write a report in this case?
Yes, I did.
Showing you what's been marked as Defendant's Exhibit VV, as in Victor. And Dr. Bolte, there is a copy of that same report in front of you.
Thank you.
If you could flip through it, 6-page report, and let the jurors know if that appears to be a fair and accurate copy of the report that you issued in this case.
It is an accurate copy.
Let's go through it if we could. The date of the issuance of the report?
It was January 31st, 2021.
When the report was finished, to whom did you send it?
I sent it to Dr. Grubbs, or Detective Grubbs, excuse me.
Let's go through. You mentioned that you went back to the scene again on November 11th of 2020. Let's talk about what you did when you went back. But before we talk about what you did, tell the jurors what you brought with you to do the testing.
So after we visited on the 6th and looked at the landscape to see what we might be able to bring to run the test, we came back on the 11th with several pieces of equipment to allow us to do a couple different tests. One was a camera, a regular camera that could take still photos and video, and a tripod to set that camera up on. We also brought a data acquisition system, which is used to, when you're running a scientific test, collect data, whether that's from an accelerometer or any type of instrument that could record motion or something along those lines. So it just is like a computer. We had a laptop to connect to the data acquisition system to collect the data. We had a inline load cell that I have with me here this morning to suspend from the branch so we can record how much weight was hanging from the branch. We had an empty milk carton basket to hold weights. We had a series of different weights of different amounts so that we could add to it slowly to see what would happen to the branch. And then finally, we had a 5th percentile female anthropomorphic test dummy, which is known as a crash test dummy, which is used to crash test when they do a frontal crash test in the United States. NHTSA, they use this dummy, and they also use it actually in a couple other tests. It is a size of a small female. It weighs approximately 105 pounds.
Were you given at any point prior to the scene on November 11th a weight with respect to the tree branch, the weight that the police office wanted you to test against?
I was not given a specific weight. I was just told a small female. And we happen to have the dummy that we could use that is supposed to represent a small female.
And the dummy, the crash test dummy that you used again weighs approximately how much?
It's between 105 to 110 pounds, depending on what instrumentation is inside of it. We did not use any instrumentation in the dummy. We just used the dummy as a weight.
Did you bring a USB cord with you?
I did. I brought 2 USB cables. I had asked Detective Grubbs if he knew a serial number, something that we could try to match the USB cable. And I went out and purchased 2 10-foot long gray USB cables that I thought were similar to the best of my ability.
Going now to what you did at the scene. You indicated that you had a camera and video. Did you run tests at the scene?
We did. We ran 2 different sets of tests.
And before I actually go into the test, from your perspective as an expert, biomechanical engineer, and you walked down there in early November and you first saw the branch, what was your thought?
As a biomechanical expert, I do not know anything about trees. So I don't know the strength of trees. So it's really, I can't really comment further than that. I know the body, I don't really know trees.
Show the jurors sort of how big the branch was in terms of circumference.
I would approximate it to have been maybe 1 to 2 inches in circumference. And it was about an inch over my head. So we measured, and I'm a 6'6", so it was about 6 foot 7 inches off the ground when we tested it on the 11th.
Let's talk to the first test that you did at the scene. Static mass test. What is that?
So we thought the first test would just be something to add weight step by step to see how much weight the branch could hold. I had no idea, as I mentioned, I'm not a tree expert. I know how to run scientific tests to look at boundary conditions or to test something that's similar to maybe what occurred there. And so we thought, let's just start with an empty crate hanging from a USB cable through this device and add weight in steps to see if we could get close to 100 pounds without the brake branching in a very static, meaning no motion, just put the weight, wait a few seconds, add the next weight.
How did you know how to tie or fasten the USB cord to the branch?
I didn't fasten the cord to the branch. I fastened the cable, one end of the cable. So this load cell records weight by pulling on it. It's a tension. So if you pull, it can measure how much I'm pulling on it right now. So we looped the USB cable through one end of it, and it had two wires coming up over top of the branch, and then came down to the basket. On the first stack test, it came back to this, and then we had a separate USB cable going to the basket. We used two cables, I believe, on the first test. So it wasn't tied directly to the tree. They were more tied to the load cell. There were two marks in the tree branch that we were able to see that we made sure the two cables from the USB were sitting in those same two marks that were already in the branch. So that's how it was set to the tree. They were in the grooves that were in the branch.
And in paragraph, the last full paragraph of your report, you talk about the discrete intervals of adding the weights. Tell the jurors what those numbers mean at the end there with respect to the static test.
Honestly, before we went to the scene, we walked around our lab to find weights that we could throw into the basket. And so we have, over the years of doing different tests, we have different weights of different masses, and we found ones that were 33, 15. And I apologize as I look at this. I know there was a 2-pound weight as well. So we got up to around 96 pounds of total static weights. We put 5 different segments of weight in before the basket slipped to the ground.
Each time you added a weight to the basket, was that captured on film?
It was. We had the camera. I forget if it was our Sony camera. It's probably stated in here. Running the entire time in regular motion, regular speed, recording the weights. The camera just ran constantly, and we just kept adding weights to it.
I want to walk through each video, each time the weights were added, and we can talk about them, and then I'll ask you if they're fair and accurate copies. We'll play the first one that we've marked as. We'll do Defendant's Exhibit UU, and we'll mark all 5 as that, Your Honor. And Dr. Bolte, the screen in front of you works as well, too. So before we play it, tell us what we're seeing here.
So what you're seeing here, and it's a little hard to see because of the branches in the background to see the gray cables, but it's an empty milk crate that is hanging from one USB cable that's tied to all 4 corners. There are no weights in the basket this time. Going up to the load cell that's in the middle there, and then again, the USB cable going up and over the tree. And as I look at this video, I apologize, there was a knot around the tree at this time. It was a knot that was below the tree with the 2 wires on top in it, but as we place the weights, you'll see the knot slipped up against the tree. Thus my forgetting at the beginning that initially the knot was not on the tree.
You can mark your screen too, but tell us you have something in front of you, and I circled something there on the scene. If you can see it, what is that?
This what you just circled is this load cell that's in there. There was a turnbuckle hook on each end in addition to what I have here today. I did not bring those, so there was hooks that we could run the wires to, but this is what's in the middle of the red there, this interface tension load cell.
And what this appears to be something in your hands there.
That is the first weight that we placed in the basket. This is a 33-pound piece of material that we had in the lab from past testing.
Let's go ahead. Came in for the second weight. That first weight was 33 pounds.
Correct.
Let's go to the next video, please. Was there a certain amount of time that you waited between adding weights?
It was a judgment weight. We just paused for a second to see if the branch was going to be stable. As you saw when I had the first weight, I didn't know how the weight would fall in the basket and what would happen. But then the knot that was just kind of between the branch and the load cells I mentioned, it slid up and tightened, and that's why the basket dropped so much, and that caught us off guard. So then we kind of waited each time to see if there'd be a little more slippage as that knot continued to tighten and tighten. So it was more just a judgment call to say, okay, the system is balanced, the basket's not going to fall, the tree branch is going to break, let's add the next weight.
Let's go to the next. As part of the static test, are you also measuring the deflection of the branch?
Yes, so we didn't measure the deflection in between each weight. We had the original height, and then once we were done with all the weight that we added to the basket, we were able to pause the film, and we calculated about, I think it's almost 3 inches, 2.96 inches that the branch deflected down from the static test.
And is that 2.96 inches, page 4 of 6 in your report? Or no?
It is 2.98 inches, excuse me. It's written on page 3, and the data, the plot that shows it is on page 4, figure 3.
And I will toggle back to that as soon as we're done with the videos. Let's look at the next video. So we're still at the static test here where you're getting nearly 100 pounds.
The last weight that I just added there was roughly around 14 to 15 pounds. And then
There's one more video. Play that now.
the last weight is identical, again, around 14 to 15 pounds.
And then in that last image, we seem to see the USB slips and the basket falls. What, if any, effect does even that have on that branch?
It wouldn't have any effect on the branch. It was just a matter of we were afraid if the milk crate was going to break. We thought we were already close to 100 pounds. Right before I put the last weight in, which would have taken, I think, to 110, we were at 96. And I felt that that was enough to say that, okay, we can hang the crash test dummy on the branch and the dummy won't break when we initially hang the dummy. So the static test was one, to see if we could get close to 100 pounds without it breaking, and then also making sure that when we try to hang the heavy crash test dummy, that it also would support the dummy weight.
I want to go back to page 3 of 6 of your report, where we talked about the deflection of the branch in the static mass test. You indicated 2.9 inches when 96 pounds was statically suspended. Just explain to us one more time what that visually looks like.
So again, the branch was initially 6 foot 7 inches off the ground. Once the 96 pounds was added, the branch at the location of the USB cable had deflected towards the ground about 3 inches.
And that finding, is that what's calculated on test 1, static max basket, in your report?
Correct. So this is the data that the data acquisition system sends to the computer that this measured the weight. And so on the bottom, you can see it says time in seconds. And so that you can see how often I added a weight. It starts at 0, and on the left is mass in pounds. And so, we started recording. There was nothing in the basket. I should state that obviously when the wire and the basket are hanging on this picks up a pound and a half, and we're able to zero that off and say, okay, we're going to call this 0 now. And so then when we start the test, it's at 0, and you can see then at approximately 4 or 5 seconds in, I added the first weight, and you can see it hung there at 33 pounds, and then you see the large jump in the data line at about 13 seconds. Can I circle? Oh. So that's at which time that slip occurred, and you saw the basket drop. That's what that is. That's that jolt from the basket. And then after that, you can see it's stayed at 33, and then about 20 seconds, I added the next 33 pound, and then the smaller 1 to 2 pounds, and then the 2 that were about 15 pounds. So the entire test lasted 1 minute and 10 seconds.
And the time interval, is what's indicated by that bottom line right there?
Yes, that's the time that each weight was placed.
You mentioned earlier about the knot that slipped. I'm just moving up page 4 of 6. Can you describe what picture B is depicting? And we'll start there.
So can I start with picture A?
You sure can. Let me zoom in so the jurors can see it. How's that?
Thank you. In picture A, you can see what we attempted to do at first. So you can see in the bottom of the picture this load cell, and you can see the little turnbuckle that was added with the hook. We ran the one USB cable up, and as I stated, there were 2 indentations on the branch, and so I ran the USB cable through those 2 indentations, and then tried to put a knot below that, and just had the rest of the wire off. So that picture was taken when the basket was hanging there empty, and then as we added weight, my knot slid up against the tree, and that's when it became against the tree. So I obviously did not tie a correct knot to begin with.
And when you talk about the knot, will you circle the knot for the jurors, or how you originally tied it and then how it slipped afterwards?
I think it's just a quick through and pulled once, a very simplistic knot. And so obviously when the mask got added, all the USB cable was able to slide through it and pull that knot up to the branch.
Let's now turn to, after the static mass test, did you do a second test on the branch?
We did, and we called that the dynamic test. It was also trying to be maybe perhaps a realistic scientific test. And we started by just hanging that small female crash test dummy to make sure the branch suspended the dummy. And then we tried to lift the dummy about 6 inches and give it a little bit of a dynamic event so that there was some energy from gravity pulling on the dummy back down.
Did the crash test dummy have its legs on it, anatomically speaking?
When we first got to the scene, yes, it had its legs. When we realized with the height of the branch and with the load cell and trying to get everything to fit, we had to take the legs close to the knees off. A female, any crash test dummy, a frontal crash test dummy, has a fixed pelvis because they're seated in the vehicle usually. And so that pelvis is at about 90 degrees. And then the legs come out, and then you have knees that come down and obviously ankle and feet. Unfortunately, dummies are built to survive crash tests of vehicles. And so they don't move like we do. They're very stiff. They're hard to maneuver. And so once we had the dummy in place, we realized the legs, as they came off the knees and down, would be resting on the ground. So we took mid-shaft femur just above the knees off. I think the report says knees. It's very close. And then once we hung the dummy without the knees, we then put the knees in the lap of the dummy and just held them there with, I believe it was tape. Just to make sure we had all the mass of the dummy there. It looks funny though because the legs were not attached. No, they were just sitting in the lap.
And this test, like the static mass, was this captured on camera?
It was. We ran video for all the events. And this event is critical because there's motion and that tree limbs are really going to bow down, perhaps break. We didn't know when we ran the test. We wanted to have the camera rolling so that we can go back and analyze the film and try to see exactly at what point, if it failed, what point it failed, or how much it deflected.
And before we play the video, tell the jurors what we see here.
So we actually ran a video while I was attempting to suspend the dummy in a manner that we felt was similar to how the remains were discovered.
And for the dynamic test, was the USB cord placed in the same or similar spot or different?
For this case, or this test, excuse me, we used one USB cable and we tried to simulate what I knew of how things were found. And so I'm staring and kind of pulling down the limb slightly there to ensure that the two cables are running through those same indentations when we set up this test.
And any information that you had at that point in November as to the remains or even the branch, where did that information come from?
Detective Grubbs brought with him one picture that showed the USB cable kind of coming off the back and how one end was hanging down. I asked because I really wanted to try to mimic exactly how the remains were discovered to make sure the test was realistic as possible.
Playing what's the 6th video in Defendant's Exhibit you, Your Honor? Tell us what you're doing right there with the USB cord.
So in this case, we used one, what we purchased, gray 10-foot USB cable. Once we got out of the package and measured it on the scene, we discovered that a 10-foot USB cable is actually, I think, 126, almost 127 inches. It's actually longer than 10 feet. And so what we did is there was this hook, remember, on this load cell. So we just doubled folded the USB cable in half, hooked it around the hook. So you had two wires coming off, ran them through the indentations on the tree. And then there was a hook on the bottom. As we came down, I used the one end of the USB just to latch in that hook, just the normal end, and it hooked. And so there was this loop then, two coming off the top around the tree, one cable coming back to the hook. And so the loop was there. And my son, who assisted on this test, helped me place the ATD then with that loop under the chin. And the second end actually then freely hung down. So the entire setup was only hooked with one end of the USB cable. So at this point, I'm trying to make sure the one end is hooked and that the dummy would actually hang before we unhook the other end to mimic the one picture.
Let's watch the rest. If we could pause it right there. What you were just doing at the branch there, why were you doing that?
I was trying to ensure that the USB wires were sitting in the indentation.
At this point in time, there's two videos. At this point in time, without the legs, do you know how much they press?
I do not know the exact number, no.
Okay. And then at some point, did you add the legs to the dummy?
Yeah, if you can go back to the beginning, you can see that the legs.
Right there?
So no, the legs are still not on at this point.
Right.
The next video, just bring it up if you would, please. Try to pause. So you can see, and I'll circle it. That is the shoe and the foot of one of the legs. So if you remember the last video, it kind of stopped with the dummy with just the knees. Here, we've now placed the legs across the thighs of that dummy, and they're in the dummy's lap.
And so initially in the last video, the dummy was statically hanging. The dynamic test, before we watch this next video, tell us what you do to create the dynamic, if you will.
Well, in this situation, what you see here is the dummy, again, is around 105 to 108 pounds, and it is sitting, you might have noticed at the end of last video, probably 6 to 10 inches off the ground. And so my son and I, and my son worked in the IBRC at this time, we tried to just lift the dummy approximately 6 inches to get the dummy in the air. And so this video starts right when we basically have lifted the dummy up and are pulling our hands out to see what would occur.
We'll start from the beginning. Dr. Bolte, is this in regular speed or slow motion?
That's slowed down.
When you dropped the crash test dummy, there was a weight that you indicated. I noticed that you ducked down. What happened as you dropped the dummy?
The dummy just ended up falling. The branch did not fail. The dummy swung down, swung up. So you'll see a little bit of motion as it oscillates until it gets back to zero. Unfortunately, I did not know. I did not want a 105-pound dummy falling on my head. So I ducked.
And it's showing you what's been marked as page 5 of 6. The results with respect to the dynamic test, are those included in your report?
They are. They're bold. kind of this sentence right here is what I thought the most important findings were, given that the branch did not fail. We ran the test twice. In science, we like to run multiple tests just to make sure that we know the correct answer or something close to that. And so we ran it twice. One time we had 6 inches of deflection. One time we had 7 inches total that it deflected before it settled back down. And the difference in those deflections is due to not knowing exactly if my son and I lifted the dummy exactly the same height each time. You know, if we had a mechanism that we could have raised it 6 inches, pulled it out, and dropped it, then you probably would see very similar findings. But you see an inch difference just because of the attempt of trying to lift the dummy and kind of throw it in the air.
And with respect to the findings regarding the deflection of the branch, what is depicted in those 2 graphs that I just bracketed?
So these are similar to the last figure that we showed. Again, on the bottom is time. And as in what we call the static test, I mentioned it took 1 minute and 10 seconds. You'll see that the time across the bottom is a total of 3 seconds. So this is a much quicker event, even though the video is slowed down. You'll also notice that on the mass or the weight on this side, you know, I mentioned the dummy weighs around 105 to 110 pounds, and this only reads 90. That's due to the way we had to conduct the test. My son and I had to already kind of have some of that mass in our arms when they hit go on the data recorder, so we don't really know what the zero was, and so you don't get the whole 105 pounds because we were holding some of that mass. And so that's why when it comes out, you see the dummy weighs around 50 pounds. That means my son and I were originally holding about 60 pounds in our arms when we were suspending him, if you will.
As you conducted the dynamic test, though, there's a point when you're not holding any of the weight.
Correct. And so at time 0 is back when we kind of threw the dummy up, you will, and the dummy starts to come down the branch. So the first oscillation, the first peak is kind of that initial when the dummy comes all the way down. And then you'll see the oscillations as the dummy and the branch kind of settled out. And so from this point 0, 0 on, we are no longer holding the dummy. It is suspended.
In total, how many tests did you conduct on that same branch that day in November?
So we conducted the static test, which took 1 minute and 10 seconds. We did the first video you showed. I apologize, I forget what exhibit it was called, but the second to last video where I was just putting the USB cable around. We hung the dummy, and then we added the legs. You could call that a test, but we didn't record any data. We were just getting the dummy in position. And then we actually, I think, total ran 3 tests where we did the lift and drop. The one test, the data recorder failed, and we didn't get any data. That's why it's not in the report. So in total, two static tests where the dummy was hanging, and then 3 tests that we added some energy to the dummy.
And of those 5 tests, how did the branch, was the branch able to sustain those 5 tests?
The branch did not fail, so I would say it sustained the 5 tests.
In addition to the graphs that we've talked about in your report, did you also include some photographs of the testing in your report as well?
There are photographs depicting the slipping knot and depicting how page 3, figure 2.
Showing you page 3 of 6?
Yes.
Tell the jurors what we see here in these 3 pictures.
So this is trying to show how we match the one photo that Detective Grubbs brought to the scene. And here in the middle, and I apologize, I'm not very good at this, but there you can see the end of the USB cable just sitting in the hook, and the tension of the dummy hanging off of there was able to keep that USB cable in the hook. And as I mentioned, you can see it up here a little bit. You can see the 2 cables coming up off the load cell going around the tree. The one comes and gets hooked in the hook, and you can see then the other one that was hanging down over the shoulder, which was similar to the picture that I was shown.
A couple questions about these. How is the USB cord around the head of the crash test dummy?
This is a point that's I'm not sure if you've ever seen a crash test dummy before today, but they don't look exactly like us. The neck is metal and rubber, and there's no skin around the neck. So you see the simple, you can kind of see right here the metal going up into the head, and then there's rubber metal. So there's no skin. So when you come down on the mandible, you do not have the skin that kind of attaches your mandible down to your neck. And so it actually gave us an advantage because we could slide the cable up along that metal rubber neck, and it actually hooked. A real person, it would have been much more difficult because of the skin. But on the crash test dummy, it was able to hang based on how it's built.
And you testified about images that you had seen with one of the cords hanging down. Is that also depicted in image 1 and 3?
It is to the best of our ability and my memory of that picture.
In image 3, it seems to be a little more clear than the video, but tell us, do you see the foot or the legs of the dummy in that image?
Yeah, so here is the knee of where it was taken off of the one side, and the foot for that one would be over to the dummy's right. And then this is obviously the shoe or the foot on the other leg, and the knee for that one would be over, almost as if the dummy was sitting cross-legged, but with the knees disconnected.
How long would you say you were overall at that scene in November of 2020? I believe it was the 11th.
I would say, I don't recall exactly, but I would say approximately an hour.
I think I asked you who was with you on November 8th when you first went to the scene. I didn't ask you, though, who was with you other than your son on November 11th.
So November 6th was the first time, to clarify. On November 11th, it was Detective Grubbs and Alloway again, and then myself, Dr. Yun Siak Kang, who was there on the 6th, and then the third person was my son.
Your findings and conclusions with respect to those tests that you administered on November 11th, 2020, are those all in the report marked Defendant's Exhibit UU?
They are.
Fair and accurate copy of your report?
It is.
And the findings in your report, those are made to a reasonable degree of scientific certainty?
They are.
Just a few more questions about the report itself. After November 11th, who did you send the report to?
I sent the report in January 2021, January 31st, to Detective Grubbs.
And at any point after the report was sent, when was the next time that an individual from this case made contact with you, either by phone or email or any kind of communication?
To the statement, just a time or a yes or no, no objection, but I just want to make sure I'm hearsay statement. Thank you.
Just the time. When did you next hear from someone affiliated, associated with this case?
I do not recall the exact date as I stated earlier, but it was an email that I received from you.
And at some point, did you and I meet at your office?
We did.
And was that just a general time frame? I won't ask the exact date, but if you could tell the jurors.
The week following your email, we met in my office for an hour and we went through my report.
The videos that we watched today, the first 5 and the last one, how did you send those videos to me? Did you give them to me?
When you visited my office for that meeting, I gave you the photos and the videos in my report, my CV on USB stick.
Your time today, with respect to your hourly rate, what is your hourly rate?
My hourly rate is $300 an hour.
Prior to me contacting you, as you testified to, has you done any work for the defense at all in this case?
I have not.
And when you conducted the tests and wrote this report, was this before or after you and I even meeting?
This was before we met.
Nothing further. Thank you.
Sir, I spoke with you just before your testimony, but my name is Corey Go. I'm representing the state and just have a few questions. Do you know Dr. Agnew?
I do know Dr. Agnew.
Okay. I told her I'd be nice to you today, so bear with me. I'll do my best. Have you ever done a test like this before?
No, we have not done a test like this.
Okay. So the videos, the report, this is kind of a first time trying this type of test. Is that fair?
That is a fair statement, yes.
Okay. First time you worked with a tree like this, I think you testified to?
That is correct.
Okay. You're not a crime scene recreationist or anything of that nature, correct?
I'm not. I'm a biomechanical engineer.
Okay. And your goal in performing this test was to determine whether the tree branch could hold somewhere around 100 pounds, correct?
Correct.
That was the only goal of this test.
That was the only goal, was to see if the branch could suspend the mass without breaking or failing.
Okay. And we saw that in the videos and some of the pictures that we've walked through so far?
Correct.
Can you stand for me, sir?
Mm-hmm.
You said how tall are you?
I'm about 6'6", if I stand the way Mom said I should.
Okay. How tall did you say the branch was when you went out there and did your initial testing?
We measured it to be 6'7".
Okay. You can have a seat. Thank you very much. A little taller than me, but that's fine. Got an extra couple inches on the ramp there, but just for the record. Again, let's talk about, you did 2 different tests. You did a static mass test 1 and then a dynamic ATD test 2, correct?
Right.
All right. Let's first talk about the static mass test, the first test you did. All right.
Mm-hmm.
And actually, before I get there, you talked about the 2 cords you used. You used 2 10-foot cords, correct?
On the static test, we used 2 10-foot cords, correct?
Okay, and those were just USB cords?
USB standard cords, yes.
Okay, so USB on both ends?
Sorry, no. USB on one end, USB printer cable to be exact. So it was a printer end on one end, USB on the other.
And other than the 2 ends of the cord, do you recall anything else being in between those 2 ends other than just the USB cord?
Just the cable itself.
Okay. So if there are pictures of the actual cord used in this case that suggest it was a different type of cord, you wouldn't have any knowledge of that, correct?
I based what I purchased off the numbers Detective Grubbs gave me and the one picture that I was shown. So I tried to match color and as best I could.
Sure. Now, when it comes to the static mass test, again, you did that test involving 2 separate 10-foot cords, correct?
Right.
Did you ever perform that test with 1 20-foot cord?
No.
So you're not able to render an opinion if there would be any differences to your test based on 1 20-foot longer cord versus 2 separate 10-foot cords, correct?
Correct.
Now, I'm going to show you what's been previously labeled Defense Exhibit VV. I'm going to zoom out first, but I'll zoom in for a couple portions here. Was this picture taken before you started adding weight to the basket?
Correct.
And there's a red circle in the middle of this picture. I'll zoom in a little bit. Can you identify what we're looking at there?
That is this interface load cell that's shown here.
And can you hold that up for the jury, please? You mentioned that there are hooks that go into the top and bottom, I believe.
So this load cell obviously has, I should know the mechanical term, but screws in a slot that you can hook other devices in. And so in the picture, you can see 2 turnbuckles with, it's better below the red. Right here, you can see the turnbuckle coming down and it just has a hook, basically.
And that's made mostly out of metal?
It's all metal, yes.
Okay. So in looking at this picture for your first test, is it fair to say this top portion here is a 10-foot cord?
It is, but you can see the tails coming off to the left side of the picture as I look at it. This cable coming in here is this cable that goes to the load cell, but here you can see some of the extra USB cable that we did not use going off to the side.
And then the bottom portion here would be the other 10-foot cord that you described?
Correct, and we used all of that because it goes down to the middle, another attempt at a knot, and then to the 4 corners of the basket, trying to figure out, or at least the handles towards the corners to figure out how to suspend that mass.
And in this initial test, you described a knot. Where does the knot begin before you start loading weight?
The knot is actually, if you can see it, is right there where those other cables are coming out. So I would estimate it's about 2 inches below the bottom of the branch there.
And that was a knot that was put there so that the cord would hang up on the branch there and not move, correct?
It was so that it would stay and not slip all the way off, correct?
Okay, so again, you have no knowledge whether there was a knot in a similar or same place in our facts and circumstances, correct? Being the case.
Correct.
Okay. Now, we watched a little bit of the video, and at some point, it's fair to say that knot slips up to the tree branch, right?
Correct.
And almost takes you out along with it. How much weight was in the basket, or how much weight did you put in the basket before that knot slipped?
It slipped at the very first weight, the 33 pounds.
Okay, so 33 pounds of weight caused the knot up top there to slip at least what looks like at least 6 inches up to the top of the tree.
It slipped up. I don't know the length, but yes, it slipped up, adding weight.
Okay. And again, looking at the dynamic test, there appears to be another knot right there at the top of the basket.
Correct.
And how is the basket being held by that apparatus, we'll call it?
So as you can see on the front of the basket here, you can see a handle. There's also a handles, the same cutouts on the sides, and we just tried to route them through there and up. And to make it more difficult on ourselves, the wire actually runs through, and the wire is actually running across in the middle in here as well. Again, my degree is not in hanging a milk carton, and so it was just trying to figure out a way to suspend this and then add mass to it.
And during this test, again, we're just testing to see if the branch would hold the weight.
Correct.
So it's free hanging as opposed to being on the ground at some point.
Correct.
Except for the part where the tree branch goes down a little bit and then the whole thing kind of collapses.
Yeah, and it's because the cables slipped, the knots continue to slip, and so it ends up on the ground before we add the last weight. Correct.
Okay, so the knot continued to slip as you added just about 100 pounds of weight?
Correct.
Okay. Now, let's move then to the dynamic ATD test. Is that correct?
Correct.
And what's ATD stand for?
Anthropomorphic test device.
Okay. I'm not going to ask you what that means, but we'll call it the dynamic test, all right?
Or crash test dummy.
Okay. Now, again, let me ask you this. Did you use the same 2 10-foot cords, or did you use something different when trying to test it dynamically?
In this case, we use one of those same 10-foot cables.
Okay. So again, not one 20-foot cable, but not one 10-foot
It's
cable?
one 10-foot cable, correct.
Okay. So if there's evidence in this case that there's a 20-foot cable, that would be different than the test you performed?
I only know what I did with the 10-foot cable.
That's fair. Thank you. How about, I guess in a similar way to the static test, were there any knots in the cable as you were trying to try to do your dynamic test?
There were not any knots in the cable when we did the dynamic test. I wish I had more of this for you, but maybe I can show. Basically, this had a hook on the top, and we just doubled the USB cable over and then hooked this. I apologize, it's so tiny, but hooked that through the hook and then ran the 2 wires up and around, and then the one end hooked back in, as you see, correct, right here. So there were no knots in the test with the crash test dummy.
Okay. And I like where you just circled there. That's a metal hook.
That is a metal hook holding the plastic aspect of the end of the USB cable.
Okay. You'd agree with me that's not a plastic cylinder or tiny plastic cylinder?
On which part?
This part here, the hook part.
No, that's a metal hook.
Okay. And you'd agree with me that this is a USB sort of end?
Yeah, I cannot tell from the picture. I don't remember if that's the printer end or the regular USB end, but that is one of the ends.
Okay. And again, even when doing this dynamic test, you're not trying to recreate the scene after looking at that one picture, correct?
We were trying to suspend the dummy in a similar fashion to the one picture that I was given.
And you'd agree with me that based on the one picture you saw, the person wasn't being suspended, correct?
The view of the picture, I could not tell that.
Okay. So again, you're just trying to determine whether even this dynamic test, the tree would hold 100 pounds.
Correct.
Just one moment. You obviously you used a crash test dummy that you talked about on direct, correct?
Correct.
You didn't have anybody willing to be a human experiment in this case, right?
Correct.
And you described this crash test dummy and the neck. Can you describe that again for me?
Yeah, so the dummy has underneath that rubber type skin, and you can see here there's the back of the, I guess you would call it the skull, is a skull cap. You can pop that off to put instrumentation in the head. So beneath the rubber is a metal skull. That is a certain mass to match anthropometry of occupants and vehicles. And then that attaches a metal interface in the bottom of the skull, attaches to the top of the neck. And as I mentioned, the neck is basically a layer of metal, a layer of rubber, metal, rubber that allows for a little bit of flexion and extension If you can imagine in a forward-facing car crash, your head will come down and come back up. So this dummy's neck allows for front to back. But what happens is, as you can see, I apologize, there's going to be a lot of lines on this, but right in here, you can see that wire pulling up on the edge of the rubber that's covering the head. That's not realistic in a human. That interaction is going to be slightly different in a human than it would be in this crash system.
Including if a human was alive and tried to move while this was happening, correct? The dummy's not moving in any way unless you're actually implementing it or doing something to make it move, correct?
I will say that the dummy's not going to move. I don't have knowledge of the human aspect of that.
Okay, that's fair. You agree with me that the crash test dummy's head kind of makes a angle there that I guess you described allows that to sort of hook under?
Correct. The head and the neck angle is specific as if the typical angle of when you're sitting in your vehicle for your eyes to be forward with your seat at 20 degrees.
Okay. I think you testified to this, but you'd agree with me that's not realistic to a normal human being when you're trying to run like this type of test.
I've never ran this test on a human, so I probably cannot answer that.
Okay. You agree with me though, just in looking at that angle, you looking at me, me looking at you, that's not something that looks like a normal person, correct?
I will say the lack of skin going from the mandible down to the neck would change that interaction.
Okay. And so the connection there would be a cord up against metal as opposed to a cord up against skin.
Skin soft tissue, correct.
Okay. Maybe just one moment, Your Honor. I have no further questions. Thank you, sir.
No. Tell the jurors why you used a 10-foot USB cord if you could.
I believe, I'm trying to recall, either in an email or a conversation perhaps on November 6th that I was told by someone a 10-foot cable, but I cannot tell you who that was because I know I specifically was searching for a 10-foot cable.
And well, you don't know the name of the person. Do you know like for whom they worked?
Objection. He just doesn't remember who he talked to, so
Well,
I was who he works for.
He doesn't know the name of the person, but he may know, and we don't know what the answer, but he may know who the person if he doesn't know where they were. If you can.
Good work, Corey.
It would have been from when I was meeting with the detectives.
One other question about you were asked if this was the first time that you had run this particular test. Does the fact that it's the first time that you've run this test impact your findings at all?
The fact that we've never ran this test does not impact the science and the outcome. The results are measured, the real outcomes. No, it wouldn't change that.
Thank you. Nothing further.
And so when you say the science, the outcome, you're talking about just that tree branch can hold roughly 100 pounds without failing?
That specific test that we ran, those results are solid for that test, which was to see if the branch could suspend the weight.
Certainly not anything specific to the facts and circumstances of this case, just the weight itself in the tree branch.
Correct.
Okay.
Any questions Alan has for this witness?
We measured the motion of the tree.
Not branch by 2. I have a few questions for you, sir. The first question is, for the dynamic test with the crash dummy, to get the correct force or weight measurement, should the force or weight value be multiplied by 2 due to only measuring force only on one side of the USB?
It's a good question. That load cell measures the amount of force that's going between the wires. And so it does not have to be multiplied by 2, I do not believe. It is fine the way it is. So.
Okay. When the knot slipped during the static test, the USB cord above the tree slipped closer together. Would this have an impact on the branch deflection?
Can you repeat the question?
Sure, absolutely. When the knot slipped during the static test, the USB cord above the tree appeared to slip closer together. Would this have an impact on the branch deflection?
So I believe the question is the two wires came closer together than we're touching on the tree. So we measured the motion of the tree. And so we had the initial level of the tree from the camera without any weight. And then we calculated the total deflection after all the weight was added. We didn't calculate the deflection of each part. So the deflection of the tree branch would not have been altered by that motion of those two cables coming together.
Do you know how much weight would have been supported by the USB cord and branch given the remains were found kneeling on the ground?
No, well, repeat that one more time. I apologize.
No. As many times as you want me to repeat the question. You got it. Do you know how much weight would have been supported by the USB cord and the branch given that the remains were discovered in a kneeling position on the ground?
No, I do not know enough data to be able to calculate that out. And we had a limit of only being able to know what load we added to the tree during our test, so I cannot answer that question.
Would body movement possibly add more weight or pull on the branch?
So body weight, body movement, motion could cause a difference in kinetic energy, perhaps, but mass overall would not have changed. So I don't think it would have changed whether the tree would have failed or not, or deflected much more, because the force, mass times acceleration would be same with the core, because the acceleration is just gravity pulling down. So I do not believe that's the case.
Final question. In your experience, would a shorter cable have more or less strength than a longer cable?
I have not tested cables for strength of length, so I cannot answer that question.
Consistent with hanging milk cartons.
Yes.
All right, fair enough. Okay, questions from the, I'm sorry, from the defense?
No, you don't think it.
All right, from the state?
No additional questions.
Thank you, sir. You are excused.
Lady Law is in the house. Hello, Lady Law. How are you, my darling? Erin Hack's in the house. Sarah's in the house. Everyone's in the house.
Lady Law.
What are we doing here?
Hey, hey, hey.
How does this defense?
Yeah.
You had an opportunity to discuss with your counsel privately whether or not you would be testifying. And have you made a decision in your own?
Oh, let's listen to Matt from the start.
With you, is this is a. You can stand up or sit down, whatever you want to do. It's up to you.
Oh, Matt did testify.
As you heard, the defense was rested, which means there'll be no more witnesses.
No, he didn't testify,
in
no.
your case.
Oh, you didn't testify.
What that
Oh,
means
okay.
is you will not be testifying. And the most important aspect of what I'm sharing with you is this is a decision that you make. Not necessarily your attorney. You made this decision in consultation with your counsel, but this is solely your decision whether to testify or not. I will tell you, you have a right to testify. You have a right, constitutional right, not to testify. And the court will be instructing the jury that they may not take the fact you chose to testify against you in any way whatsoever. And I want you to be aware of these choices you have. So I would like to ask you, have you had an opportunity to discuss with your counsel privately whether or not you would be testifying? And have you made a decision in your own mind as to which decision you'd like to make? And that decision is that you will not be testifying in this case. And the court, with the understanding the court will be rendering that instruction to the jury. All right. Counsel satisfied?
No, just for the record, the instruction is the fact that the defendant has not testified cannot be used.
Did I say you did testify? Oh, I'm sorry. Yeah, the fact that the defendant has not testified cannot be used against him anyway. I think you and I are on the same page. We corrected that. Okay. All right. And the court will take under advisement your request for Rule 29. Does the state have any rebuttal evidence you wish to present?
Yeah, I will not be calling any rebuttal witnesses.
Okay. So we're, I guess, at the point where ultimately when the jury comes back, we will be going into closing arguments. Now, I had mentioned to you on the phone, and this will be a decision you can make, not me. I offered, if you wanted, to read the substantive portion of the instructions prior to closing. I have done that before. I don't know if that's the culture you folks do. So I am wide open. I offer that if you wish. Otherwise, we'll just do the traditional closing arguments, and then I read the instructions. Do you have any thoughts one way or the other about that?
I do, Your Honor. I like the suggestion. I was up for something new. I think it's, I like the court to give some preliminary instruction before we go closing.
And just to make sure everyone understands what I'm saying, I will do all the instructions as you have, all the way up to the point where it says to read the verdict forms and go over those with them. I will not be doing that. That will be after I have concluded. And then what I call the boilerplate about their behavior and conduct in the jury room, that will also be done at the conclusions of all the arguments.
Does the court also send back a copy of the jury instructions?
Every single one of them are going to have a copy. That's the practice in this court.
Judge, I have no objection to that procedure either, although I would suggest, obviously, if we take a little time to have a quick break here. By the time we get them back in and we read the instructions, we're going to be very close to the lunch hour. I expect closings to go on for a good chunk of time. It would be my preference.
Right. This is the jury coming back in, I believe now. Oh, maybe not. I've gone past it, maybe.
Lengthy break. Limited to the duration of the time of the defense closing. And I'll keep the clock on that, so you don't have to worry about it. And I'll give you a 5-minute warning. If you're pushing, next step in the case, read top of page, tell you it's good.
Right, see what happens here.
All of the evidence that will be presented.
Here we go.
Ladies and gentlemen, I am going to announce to you that you have now heard all of the evidence that will be presented in this case. The next step in the case is for the court to provide you the instructions of law and counsel to provide you their closing arguments. What we were going to do is to provide some context to the closing arguments. I am going to read to you a portion of the jury instructions, including the definitions of the 3 offenses that are alleged in this case. I want you to listen to those. You're going to get copies of these, so you don't have to take notes on what I'll be reading to you. I will do so. When I've concluded that, counsel will then give their closing arguments to you. And then when they have concluded, I will finish with the instructions that are remaining. I think all of that is going to take a significant period of time, the instructions as well as the argument. So I think it might be appropriate before we get into that to take our noon break. So we will do this now. It'll give counsel an opportunity to put their thoughts together, give you a chance to take a nice lengthy break, understanding that we want you fresh and ready to proceed with the final portions of this trial. And then, of course, obviously, once we have concluded the closing arguments and the instructions of law, you will then retire to begin your deliberations. So that's where we are in this case. So at this point, without being influenced by your verdict, proof, the law,
Right.
I'd
the fact.
like to talk to you.
Okay.
Just jumping.
So this is the closing now. Right, Matt, did you want to say anything, or anybody want to say anything about the last witness at all?
I think that it was more filler. I don't know why Diane decided to call him up there. It was something about the strength of the. But I mean, if anything would have came up of significance, it would have been the prosecution would have used him. I didn't understand. I didn't really get at. I guess she was trying to make the point that they hired him. They didn't give that. The doctor didn't give them the results that they wanted, so they just said, "Well, fuck them." But I don't know what else we want them to do. I mean, what do you want? I don't understand that point either. I think she took kind of. Well, you didn't hear anybody from that was related to this case after you got done giving them the results of it, and then they didn't say, "Hey, come testify for us." So I guess that makes them look a little suspect. I don't know.
Yeah.
I didn't get.
Yeah, I think that's exactly what it was. But
okay. I do think technically it did serve. At least it showed. I mean, to me, when I
Yeah, Kara, I said Matt's on echo. That's fine.
Oh, okay. No. It's. I was only gonna say I think the guy's testimony only served as kind of. It was to show, in my opinion, how the hanging would have been possible, in the way that I don't know how to explain it. I don't know how to explain it, but based on the theory of the case that the hanging didn't happen, I think it did serve. It didn't. I don't think it landed properly, because what he was saying was it will be easier to test it on a dummy that it will be easier for the dummy to execute it than an actual human. That's what I heard from all that. But I was thinking that the technique behind it was to show that it was possible, that she did hang. You know, that's what I think on the technical level. Huh?
The branch held. The branch didn't break. She was able to do what she did with the branch. The branch.
Okay.
Yeah,
I get that.
But
that's what I was thinking.
If it did break, they would have brought it in, so it didn't break. So I mean, why bring it in? I mean, other than what I think they just wanted them to look like they hired this guy, and then when they didn't get what they wanted, it's more evidence of tunnel vision, right? It's more evidence of them just pretending like, okay, well, it didn't work out. Let's go on to the next thing.
right.
Okay, well, as you say, a bit more. Yeah, fine. The important bit, though, we're here for closings. This is going to be the part that's most interesting. I'm looking forward to this bit. So let's listen to this. We've also got, I'm not sure.
Is this like a finale stream? Oh, I'm going to miss you.
No, there's another stream after this. There's going to be another stream. So we're going to do. We're going to do.
You got Corey, that the skinny, tall redhead. He does the final argument. Man. It's crazy.
Yeah, he does it. No, so there's going to be another stream next week where we do the verdict and the Matt's ending stream. So as in, whatever he wants to say. So we'll do another one probably next Thursday. So yeah. So just closings, then that's it for today. So yeah, it's nice to see everybody. We got, obviously Lou's in the house, old guards here, Lady Law, back at your ketchup dude. Hey Lou. Oh my God, Josie, we're on closings. Yes, we are. Yeah, because there's been a lot of buffer, a lot of filler. But right, Jesus Christ, who's that? I'm not sure who that is. No, it might be Matt.
I mean,
Matt's in a hurricane.
That's a different level.
Or is that Mighty Me in the toilet or something? I'm not sure.
No, Matt's in a hurricane.
Oh, is he in a hurricane? Is he?
Yeah.
Oh, well, I didn't know. I thought you might have a bad tummy, Mighty. So.
Yeah.
We got sound problems out here, man.
It's all good. Well, we're not. Hopefully, unless it's something significant, we'll go through these and we can comment after each.
Any questions at all? I'm gonna find it very hard not to chime in on everything this fucking asshole says because he's lying. So it's gonna be tough for me, but I'll try to get through it the best I can. Know that this man, he went on I'll have to explain it to you. He went on Dateline NBC, and he said completely different things than he's saying in his final right here, because he knows it didn't work here, and they know that after it's over. I mean, who's going to say anything to these people? He went on Dateline, and it was, you have to go. You have to watch the Dateline. It's called The Clearing. That's the title of it, and you have to watch it. And at the end, it's damage control. Literally, it's damage control. He's just. These guys, just let it go. I'll do my best not to talk so much.
No, it's fine. You can jump in later. It's just more of it'd be nice to get the context of it, you know. But obviously, if there's anything you want to jump in on, then jump in, man. You know,
this is all that we've done over the last 23 weeks. Here it is. It's just like this is their case, man. This is why I went to all this. This is it. It's laughable. It's fucking disgusting, really. All right, go ahead.
Right, let's go. I'll be back as well. Just going to drop to the toilet. I'll be back. So you go.
My colleague started this trial all the way back with opening statement.
If you just stop in the next 2 minutes, Matt, tough. I'm leaving it go because I need to go to the toilet quickly.
All right, no problem. No sweat. No sweat.
At least 2 minutes. 2 minutes.
Talking about a book and skipping to the end and looking at things. I'd like to talk about something a little different. I'd like to talk to you about a movie. There's a movie called The Usual Suspects. Came out in the mid-90s, where Kevin Spacey is the main character, and the point of the story is he's narrating or discussing events while he's sitting in a police station. Now, spoiler alert on this 30-year-old movie is that at the end of the day, it turns out that Kevin Spacey's character was the main criminal mastermind the entire time. It only becomes clear as he walks out of the police station at the end of the movie that the detective then looks and realizes that Kevin Spacey was weaving together a story based on a word that was on the bottom of a coffee cup and some things that were posted on a bulletin board. Only at the very end of the movie, then, do you see the revelation. And then you can go back and look at the things that happened early on. And suddenly, it all starts to make sense. And you see how those pieces fit together that you missed the first time. Now, ladies and gentlemen, in presenting a criminal case, we, as a state, have a burden of proof, and we have to call witnesses to bring to you the evidence in the case. Each witness brings their own piece or pieces of the puzzle. Now, you'd be forgiven for the first week of this case, wondering what was going on. These witnesses seemingly coming in and just throwing random pieces of a puzzle onto a table. What's it leading to? What's the point? I submit to you that when you get to the end, it all starts to make sense. And so what's the first thing you have to do when you're putting together a puzzle? You got to put together the border. You got to understand what you're working with. What are you looking at? Ladies and gentlemen, there's only two possible borders here to this puzzle. One is Emily Noble committed suicide. The other is Emily Noble died of a homicide. Let's talk about that. Emily Noble died of multiple injuries to her face and neck.
No.
Uncontroverted
multiple injuries to her
Nothing
face.
to dispute
There was one injury to her face. He's right there. He's doing it again. She had one injury that we made out it to be a not even an injury. And not only our board certified forensic anthropologist, Dateline went out and hired 3 more, and they all agreed that it was a phantom injury. It didn't even exist. And it was just one injury. This man just said that there was multiple injuries to her face. He's lying. Go ahead.
Cause of death. This isn't a situation where she walked into the woods, had a heart attack, and fell into a cable that happened to be strung up from a tree branch. She's dead because of the injuries she sustained to her neck. And there's no accidental explanation for how they occurred. So there's 2 options, and only 2 options. She sustained those injuries to her neck because of suicide, or she sustained those injuries to her neck because of homicide. That's it, period. Those are the 2 choices. Now, the state of Ohio has a burden of proof. It's beyond a reasonable doubt. And we don't shy away from that burden. And the judge has instructed you, and it's absolutely correct.
2
Just because
options,
the defense
doesn't
put
that
on
make
some
it
evidence,
reasonable doubt?
just because they raise this argument of suicide doesn't shift the burden to them in any way. It's our job to disprove suicide beyond a reasonable doubt. But when you listen to their arguments, when you listen to the testimony they did present, you have to ask yourself, was it reasonable? Does it make any sense in light of the other testimony? Ladies and gentlemen, I submit to you that the evidence is clear and that it proves beyond reasonable doubt that Emily Noble did not die of suicide. And let's talk about how you know that.
I mean, going back to
First
that
of all,
movie thing,
there's no
I
note.
think you should have just brought in a real life
No
story
communication of any kind.
and work from that framework. Why are you using a fictional story? That just, I'm sorry, that threw me off. I'm done listening to him after that. I'm done listening to him. Sorry, continue.
A stupid fucking movie Where this fucking
Art-
you ever
You
see
know
it?
what I
You ever see
mean?
you ever see the movie? You ever see it? It's fucking horrible.
Yeah, I love Kevin
Horrible, for
Spacey.
one.
I mean, like, let's not get into the controversy of whatever is going on. But as an actor, like, I'm his biggest fan. Like that movie is great and all, but like, it is supposed to be impossible for a reason. It's supposed to be, like, come on.
They're saying that the only way you can believe their story is if I'm as smart as the characters Kevin Spacey's character is in fucking that movie, Usual Suspects. This the only way you can juggle their facts to make it. This guy is like a mastermind, right? There it is. What
Our
the fuck?
case is as unreal as this movie.
They should be prosecuted for what they did to me, and I don't know why they can do this to people because they can do it with impunity. They can get away with it, and there's nothing anybody can. Well, why don't you go get a lawyer? Because they're all in on it. Nobody. You know how many lawyers I called? Do you know how many fucking lawyers I called to try to get a wrongful prosecution case going? Nobody wouldn't even. No one wanted anything to do with it because they're all in on it, man. They're all part of the same club.
You could have quoted JFK, man. JFK.
With anyone.
Sorry.
Hey, I'm really struggling. Hey, I'm having bad days. Hey, I just don't know if I can go on anymore. No goodbyes to loved ones. No explanation.
Oh yeah, that's another thing. I'm sorry.
Nothing whatsoever.
No note, right? Over half of people that commit suicide don't leave notes. Over 50%. And they're using that as evidence. No note. Not telling anybody.
Oh my God.
It's ridiculous. These people can say anything they want.
Yeah.
You'll have search history on her phone for 6 months, roughly. What's on there? Not a single thing about suicide. Nothing. It's about plants and weeds and foraging. Well, wait a second. There is that T-shirt with a quote on it about going into the woods. That's it. That's the evidence of suicide? That she was thinking of suicide? She looked at a T-shirt with a quote about the woods sometime in February? That's ridiculous. Nothing on that phone whatsoever to suggest that she's suicidal.
That's
Who
wrong.
else tells you that?
I
Her
have
friends.
I have her transcripts to her to all her text messaging to her friends. There wasn't any mention of it to me. There was, but it was like really kind of like. But she was talking to a friend about her abuse right before. You guys remember? I talked about that Jennifer girl, the friend. Jen was worried about her that night. Remember, she called back and Emily didn't pick up. There is evidence of Emily being suicidal in her text messages to that girl Jen. She was talking about, and it was like a week before that she did this. So for them to say that, it's just not true. I don't know what else to say. I have the transcripts. If anybody ever wants them, read them. If you can't see that she was suicidal, then you're not fucking paying attention. These cops just didn't want to hear it. Literally, they said murder not even 24 hours after I called her in missing. Mighty me. When with no evidence? When does that ever happen? I watched a TV show today where a girl that was like 14 went missing, and they said no, it's too early. A girl, what? A 14-year-old goes missing? You're not going to start looking for her? No, it's too early. You need some. This was a grown woman that wasn't even missing for 24 hours, and they said murder already.
They won't even take a report in Michigan if it's less than 24 hours. If it hasn't been more than 24 hours, they won't even. They'll be like, nah, call us back if they're not home in 24 hours.
This was a money grab. They just started spending money.
Mm-hmm.
That's what this was. Yes, he's lying. Sleeper's lying. There is evidence of her being suicidal in her text messages. Weeks before, I don't want to say weeks before. It was just a short time before. She was talking to that friend Jennifer on the phone, and she was discussing how fucked up she was in the head over what happened to her when she was a kid. And if you look at the counseling records, she's constantly mentioning it. And I know all of her friends, if ever they listen to this, I know that she was suicidal. I know you did. If you knew Emily, you knew there was something wrong with her, or you just weren't paying attention. So, but as far as the text messages, there was plenty of evidence in the text messages that she had problems. So,
Does Diane go into that then?
Diane? Yeah.
Yeah.
All that.
Yeah, fine. No, that's fine.
I'm sorry. Yes, she does. Yeah.
No, it's fine. I was
Absolutely.
going to ask you more about it, but if Diane does it, it's fine. We don't need to know then. It's fine. We'll cover it when she gets to it. It's fine.
Now, guess what? The only person who could come in and talk about how she was doing the entire time is dead. Emily Noble's dead. She can't come talk to you about everything. So we have to bring in people that know snapshots, pieces, that see her at various times throughout the years. And what they all tell you. Did any one of them come in and tell you that they had concerns that she was
Friends
suicidal?
don't want to
Concerns that she was
admit.
gonna harm
Family
herself?
and
No.
friends, the people that commit suicide, do never want to admit that they didn't know. It's just a thing that they do. It's hard for them to admit that they were close to someone and that close person killed themselves. They don't want to admit to it. They can't. Their friends are on Dateline saying, I know that Emily didn't commit suicide because her sister asked her if she was suicidal after her husband died and after Joey died. They asked her sister Amy asked her if she was suicidal, and she said no. So that's how I know she's not suicidal. It's like, what? I mean, that's denial. That's denial, right? I mean, that's someone who should know, a friend of hers that should know that she had problems. I mean, you can't see that coming. It's beyond me. It's beyond me how this man can say that, and how anybody that's paying attention could not see it. Sorry.
And you know who else tells you that? The defendant. You know when he tells you? The 911 call. He calls right away. He's talking to the dispatcher, and they say, did you guys have an argument? No. Well, no. Oh, was she depressed? No. He tells the dispatcher right away when he calls law enforcement that his wife was not depressed.
Matt, I'm going to mute you, Matt.
Oh, something wrong with my sound.
Yeah, because you come. No, it's fine. Just whenever you want to speak, just unmute yourself every time you want to speak. Okay, Matt. Oh, he'll be back.
When Officer Hollis responds to the scene, he tells him that she was the squarest, straightest person he knows. Okay. Now, later on when he's talking about it, he's asked, well, she's an emotional person, but no more than any other woman. Even the defendant doesn't bring forth right away talking about her being depressed or being suicidal. Nothing. Now, Emily Noble had been through a lot of trauma. No dispute about that. Awful, awful things. Starting from friends dying of AIDS in the 90s, her first husband killing himself, her dad slipping and falling and hitting his head and never recovering, her mom dying in a car wreck less than a year later. Terrible things. But what do you hear about that? That each time Emily Noble overcame that tragedy, overcame that trauma, and continued on to see the joy in life and the bright things in the world. She got through it every single time, until she married that man. And now suddenly she doesn't survive the trauma. Who's the first witness you heard from? Amy Thomas, Emily's sister. And she told you about their relationship, about they've been around. And she told you that Emily had seen what happens to people who are left behind when someone commits suicide. You know that. Her first husband committed suicide. Her stepson committed suicide. She knows what happens. And she had conversations on multiple occasions with Amy where she promised that she would never harm herself, that she would never commit suicide.
I beg
So what is it?
So much. I actually didn't.
That would allegedly lead her to commit suicide in this instance? Well, it's Joey, the stepson she lived with for a little over a year. That's the one she can't overcome? Now, the defendant, in what I would submit to you is one of the biggest understatements I've ever heard, says in his interview, after my son died, there was some tension and stress. She dealt with it differently than I did. Yeah. How did Emily deal with it? Emily took time off work. Emily went to counseling. Emily told the counselor repeatedly that she was concerned for her husband's well-being. Now, you're going to have some records of some of these counseling records presented to you with no context, no testimony, but they contain in there statements that Emily made to her therapist. Look at them. There's not a single mention anywhere in there of suicidal thoughts or suicidal ideation. Not a single one. In fact, what they submit to you show is somebody who was going there, working through the issues, and reported getting better, who went back to work part-time and then says that she's ready to go back to work full-time. They reflect that she's trying to eat healthy, that she's doing yoga, that she's going out into nature, that she's doing the things that she needs to do to put herself on the right path. And what's the defendant dealing with it differently?
What the hell?
He's unemployed, sitting at home, getting drunk.
I can't believe.
Just ask yourself for a second. We told you that somebody in that house, that one of these two adults committed suicide. Isn't it more likely to be the defendant? The one whose own son committed suicide, who never saw counseling, who never did anything to address the issues, would sit at home and drink. But instead, they want you to believe that the individual who confronted those issues, who sought therapy, who was doing things to get better, is the one who just couldn't take it. That's not reasonable. That's ridiculous.
I've never heard them make this argument. Like, did they actually make this argument during the trial? Because if they did, I'm sure they would have brought out like an expert that would pretty much lay the statistics on what happens when people do suicide or something like that. Because what he's saying here is something that is pretty common, that people that tend to do it put a brave face on, and they don't even like actually show anything to say that they're in trouble. And then when it's too late, then they start seeing the signs that, oh, this guy was actually, you know, XYZ. I don't know. I could be wrong. I'm always wrong anyway. Sorry to interrupt. That just pissed me off.
You heard repeatedly that Emily was healthy, was working out, was taking walks. She's eating dandelions and weeds and other things, which is apparently healthy for you. Probably better than I've been eating in the last 2 weeks. But she's even, you heard testimony that she said she was in the best shape of her life. How much you hear?
Sleeper's a
Celeste
suicide
said
expert.
that Emily had a pin taken out of her ankle.
How the fuck would he know?
That she finally didn't have that pain anymore. You can see on the body cam when they discuss that, the defendant doesn't even really know if his wife has a doctor. Doesn't seem to really know or care where she works or know any of her coworkers or any of that. But Celeste does.
I see why you were pissed off.
And wouldn't you know?
He said that I didn't
Wouldn't you know
seek
it?
treatment
The
for my
forensic
son.
anthropologist at Ohio State,
You didn't
Dr.
say that?
Agnew.
I don't think we got.
He said I didn't seek
I
treatment
missed
for
that. I
Joey
missed it.
when Joey was sick. I mean,
Looks at those remains and says, there's evidence of previous hardware in the ankle is no longer there. Emily was in a great place. What about any of this would lead you for a second to think that she was going to commit suicide? She was going to kill herself. And what about the timing? What about the timing? May 24th, Emily's birthday. May 25th, the other day that she and her sister Amy are the same age. May 26th, Amy's birthday. You heard testimony that this was a special time for them every year of their lives, from the very beginning when Emily was brought home from the hospital on Amy's birthday. That they would call and talk and have a special conversation, that they're the same age in those days. This wasn't a random day or a random time for Emily Noble. These dates were important to her, meaningful to her. So remember that sister that she promised that she would never commit suicide to? Now Emily, without warning, without speaking to anyone, without a note, goes off and hangs herself during that special time? To do what? Inflict maximum pain on her sister? Why in the world, if she was going to commit suicide, would she do it then? That's a special and happy time for her. Not a time when she would harm herself. Let's talk briefly right now about the defendant's version of events, and as you might imagine, we'll come back to this again later. But what's the defendant say? You gotta love the body cam. Gotta love the body cam because it shows you what the defendant's saying, how he's acting, and you can see those interactions inside the house. And I'll tell you what, I want you to go back and watch this. Officer Hollis is inside the house. He looks in to the master bedroom, and he says, the bed's made. I submit to you, the defendant, before he even walks around to where he can see, before he even looks in there, he goes, oh yeah, I just noticed that. And just notice that. And then he says, she must have made the bed. Because remember, his version of events is they come home from uptown, they have sex, they go to bed, he wakes up in the middle of the night, has to go pee, goes out in the other room, right? So his version of events is his wife, Emily Noble, was in that bed sleeping around 1:30 in the morning. That bed is made. So, oh yeah, she must have made the
people
bed.
make beds.
So, ladies and gentlemen, the person who has repeatedly triumphed over trauma in her life, the person who has
He's
sought
talking
treatment,
about 6
the person who
o'clock
is
at
by-
night when I called them to come in to look, right? When I called Hollis in, that the bed wouldn't be made at 6. If the bed wasn't made, I would be like, oh my God, it's 6 o'clock. That bed's not supposed to be unmade. That would have been weird. The bed being made at 6 o'clock, I mean, why is that strange to him? She made the bed. So is that strange to people that she would make the bed? I don't get it. Help me here, guys. Can you hear me?
Yeah, I can hear you.
Yeah, I can hear you, man. No, there's nothing. Yeah, there's nothing strange about it. So
I mean, if she left when Kramer saw her, which is most likely is when she did leave in the morning on Monday, she would have made the bed, bro. She always made the bed. This is one of the first things she did when she got up was make the bed. I noticed when he said, hey, the bed's made. And that's right when it clicked. I didn't make that bed. Dude, I did not make that bed. I got out of it, went into Joy's room, and got up the next day, and the bed was made. I didn't even notice it because it was made. It was normal. And the day goes by, and all of a sudden, he's like, hey, the bed's made. And I thought about it. I'm like, yeah, I didn't make that bed. I slept in that fucking bed last night, and it's fucking made. She made it. And what's their point? Beats me, man. I don't know. That the bed's made? That someone that's suicidal wouldn't make their bed before they go kill themselves. That's their fucking point, dude.
Not depressed, or had never said anything that would have caused him to call law enforcement to try to get his wife help that she was going to harm herself. The person who's healthy and in the best shape of her life. The person who just went out to celebrate her birthday, who's celebrating a special time of year in her life. She wakes up randomly in the morning, never touches her phone to respond to any other questions or comment or text that she'd received, makes herself a drink, makes the bed, and wanders off into the woods to hang herself. Really? What part of that is a reasonable explanation of what happened? What part of that is reasonable? I submit to you it's not reasonable. It's ridiculous. But guess what, ladies and gentlemen? You don't even have to stop there. You heard from a man named Dr. Smock. Let me briefly summarize his testimony. That cord, that ligature, it is impossible for it to cause the injuries to Emily Noble's neck. He says the quadruple fracture pattern, the fracture on both sides of the hyoid and both sides of the thyroid cartilage, has never been documented in somebody under 100 pounds in an incomplete hanging. In fact, he tells you in one study, they didn't even document a single fracture of any kind in the neck for any hanging of an individual under 110 pounds. Even complete hangings where the full body weight is being put on that ligature in the neck. Not a single one. Allow me to briefly summarize the cross-examination of Dr. Smock. He spelled Dr. Hardin's name wrong. All of the bluster, all of the theatrics, it all crumbled when confronted with the testimony of Dr. Smock, who I submit to you is the single most qualified person that you heard from in this entire trial. He is the expert on these things.
Mighty meat.
On strangulation, on staged crime scenes. And he tells you, based on his training and experience from all over the world, that this is a staged suicide. And what's the response to that? Dr. Garvin, I submit to you, she's board certified in garbage in, garbage out. She didn't do a full analysis. She did what she termed a case review. And spent a lot of time on the witness stand talking about that case review. It contained earth-shattering revelations that Dr. Agnew didn't use 2 standard deviations when determining the age of the remains, or that she only used one method in determining the ancestry. Who cares? On cross-examination, Dr. Garvin admitted that none of that impacted her ability to review the trauma in the case. Well, the pictures of the trauma anyway, of course, because she didn't bother to look at the actual bones, but the pictures. For all the talk that she had about best practices of not using hydrogen peroxide, and if you read that, it actually talks about not using hydrogen peroxide because you want to consider the possible hazards to the user of this substance, not the bones. But for all that talk of best practices, she didn't follow the simplest, most straightforward best practice in forensic anthropology. Look at the bones. Look at the bones. So she looks at 2D pictures of this. And what she say? Well, she assumed that they were gone. She testified that she has spent 50 hours researching and looking at things here and talking to colleagues and all that, but never once at any point thought, man, I've looked at these pictures and I don't see the same thing as the person who actually looked at the bones. Maybe I should ask to look at the bones. No. Let's talk about two parts of her report that matter. The facial fractures, the nose. One person came in and told you they examined the bones under a microscope. They told you that, as you can imagine, sometimes you have to turn things, get it in a different light, look at it from a different angle to be able to see all the detail. That's what Dr. Agnew did. Dr. Garvin took a piece of paper and looked at it and said, I don't see the same thing that that person did who was actually looking at the bones, following the best practices. It's one thing. It's one thing to look at a photograph and say, you know what? I see the same thing that that person did to look at the actual bones. And spoiler alert, that's what Dr. Garvin says with regard to the injuries of the neck. It's something entirely different to say, I'm looking at this photograph and I don't see it. And then look at the way that she wrote it in her report. No evidence of perimortem trauma to the craniofacial region. But in all the rest of the report, it's no definitive evidence. No definitive evidence. Not the same thing as saying no evidence whatsoever. Now, ladies and gentlemen, obviously, the facial trauma would be a good fact for the state because you don't get a fracture in your nose from putting a cord around your neck in a suicidal hang. But don't for a second think that that's the linchpin of this entire case. The nose fractures aren't what caused the death. That's what happened in the neck. Now, I want you to see if you can spot the difference in these two sentences. One, I did not see anything inconsistent with perimortem trauma to the thyroid cartilage and the hyoid. Or, I agree that the thyroid cartilage and hyoid fractures are perimortem. The first one was Dr. Garvin's testimony on direct examination. Made it sound like she just didn't see anything to dispute Dr. Agnew's qualifications. But in her report, she literally wrote that she agrees that those are perimortem. So what does she attempt to tell you then about those perimortem fractures? That you can't rule out hanging as the cause. Why? Because somewhere a 240-pound man had those fractures in a hanging? Dr. Garvin can write, she can choose any study she wants. And writing her report, she's under no obligation to spell out everything she's ever read or where she's ever gone or anything she's ever learned. She's not to type it all out. But she chose to type out something in support of her conclusion. She picked one study that she says supports what she's talking about. And ladies and gentlemen, that study says nothing of the sort. The Zedekova study, in reviewing 178 cases of hanging, found the quadruple fracture pattern in 3.4% of cases. So already we're talking about in the study that she cited, 96% of hangings did not have those fractures. 96%.
It doesn't say anything about when they found her. Most hangings, they're found right away. They don't hang from the rope for 4 months out in the woods getting blown around. It's just he's being disingenuous. The jury saw it. So, but I mean, if you listen to this guy, he's got it right. I mean, but he knows. I mean, he knows what he's doing. He's misrepresenting what we all just watched when it came to the experts, saying that it never happens. All right. Well, how many times has there been a hanging where the person is left somewhere for 4 fucking months, and then you look at the fucking fractures in her neck? It's not in the literature. So,
well, I just look forward to Diane's how she combats all this. Do you know what I mean?
Right.
Because I believe she's gonna. Well, I imagine she's gonna combat everything that he's just said.
Not everything, but she does really good. Yeah.
Yeah. Okay.
Garvin believed it was important to determine how many of those were incomplete and how many of them were complete hangings. So she emailed the study author. And they wrote back. 3 out of the 6. 3 were incomplete. But that's not all they wrote. Ladies and gentlemen, I submit to you there's a thing called a lie of omission. It's when you give a statement that's true, but you admit the other important facts. You're not outright saying something that's not true. When Dr. Garvin wrote in her report 3 out of the 6 were incomplete hangings, that is true. But what'd she leave out? The next part, that the author of the study in his one sentence reply said, by the way, 2 of them are overweight. She leaves that out of her report, but admits that age-adjusted weight is a statistically significant factor in determining whether or not you're going to see fractures. Even worse, that study cites another study that says in cases of individuals under 110 pounds, they didn't find a single fracture. Not one. When you look at the underlying data of the study she cites, it's clear it doesn't support the conclusion. Even within that study, there's something that directly contradicts what Dr. Garvin ends up telling. Because again, we don't care if somebody somewhere in a hanging had that quadruple fracture pattern. Who cares if it's happened ever? What's important is, did it happen to Emily Noble? Did it happen to this 100-pound female who was in an incomplete hanging? And you'll recall, Dr. Smock testified and he said, there is no such case documented anywhere. There is no such case. And who agreed with it? Dr. Garvin. I asked her at cross-examination, if in the 50 hours of searching and then talking to colleagues, if you'd found a single study that ever had an individual under 100 pounds with this quadruple fracture pattern, you would have brought it with you to court. She said yes. The fact you don't have that tells you all you need to know. Even more evidence that this isn't suicide. It proves beyond a reasonable doubt that it's not suicide. Dr. Hickman, the Delaware County coroner. Now, you've heard some questions that seem to give the implication that somehow the state paid for an expert report, and after that, then Dr. Hickman issues a death certificate. That's not what Dr. Hickman tells you. Dr. Hickman tells you that when he got the report initially talking about the quadruple fractures, he already in mind was saying, this is not suicide. Dr. Hickman might have been the only witness in this trial that really did a good job explaining what this hanging would have looked like. For as many times as defense counsel was down on the ground demonstrating the position of Emily's body, I didn't see her a single time show what would have had to happen to put the weight on the neck, to constrict that ligature. Because it isn't enough to say, I've got a cord tied around the tree and I just rest my head in it.
She did.
I'm going to do something to put pressure
She went
on the
from
neck.
100 pounds, right? 95 pounds, 100 pounds to 19 pounds. She shrank. That alone could cause enough pressure or whatever you want to call that type of thing to break those bones. We proved it.
And how did Dr. Hickman describe that? It's a lean into, that you have to lean into the cord, into the ligature. In a complete hanging, you're on a chair or a stool or something gets kicked out from under you and you can't touch the ground, all of your body weight is in the neck. In an incomplete hanging, not all of your body weight is there. And just having a cord around your neck and staying on the ground doesn't do anything. You got to lean into it. You got to do something to make that pressure. Ladies and gentlemen, look at the photos. No end of the cord is tied around the tree. One, what I call the traditional USB, is down on the nose back. The other end of the cord, what I call a micro USB, the Detective Grubb said fit into some of the old cell phone devices in the house, has this fat plastic piece on it. And you'll have the real cord. Get it out, look at it. The only thing holding that entire contraption together, loop tied in the middle of the cord, hanging down from the tree, fat plastic piece cut, just like that. Not tied, not knotted, just that. This fat plastic piece cut on the loop. Ladies and gentlemen, you don't need to be a doctor. You don't need to have any specialized knowledge to look at that and say, that's ridiculous.
That held on
That's not a manner
for 4 months. She was found hanging from that. 4 months in the woods. It worked. What's he talking about? Because he pulls it a certain way and it comes out. That's proof. What is he saying? That's a day before they found her, someone brought her there and strung her up like that. That's why. You know what I mean? 4 months she was out there, right? 4 months, 3 months, whatever.
4 months, I think. 4 months, Matt. Yeah.
It worked. What's he saying? What's point is he trying to make? He's just trying to tell you a story that isn't true.
Well, it's not believable story. So his story is not
your
believable.
point there. And how do we know that's the? Do we see anything? That was the first time I saw anything about the knot. What about the knot? I guess we're just supposed to believe you because now you're in final argument. So now you can just say anything you want. How do we know that that's the type of knot it was? We don't know. We didn't see anything. I didn't see anything all trial long about how anything in particular about the rope. Did Schmock say anything about the rope? He's supposed to be an expert, right? He can tell whether someone if it was her that did it or maybe someone else did it that strung the rope a certain way. They just said, "Hey, this is a staged suicide." Why? They didn't say shit. All of a sudden, you got final argument, and he's like, "This is the way it was. This is not how you would hang yourself." How do we know?
Which anyone would hang themselves? It's not a way that somebody would commit suicide. Emily Noble's death was not suicide. Would submit to you, that's what the evidence proves, beyond reasonable doubt. It was not suicide. Dr. Smock tells you that. He says this was a staged suicide. No one else. Dr. Hickman tells you this is a homicide. This is manual strangulation. The defense witness isn't in a position to opine on that. A forensic anthropologist doesn't tell you cause or manner of death. The only thing that Dr. Garvin is saying is that you can't rule out hanging as a mechanism. Not suicidal hanging, not anything else, just saying a hanging can't be ruled out. And again, I submit to you that her opinion is not supported by anything that you've heard of any of the literature, and it's not supported by the only thing that she cited in her own study. So, ladies and gentlemen, if this is not suicide, what is it? It's a homicide. In order for someone to be held criminally liable in the state of Ohio for a homicide, we have some statutes. And the ones we're talking about here are murder. And I want to give you a little piece of it just to help orient and understand what we're talking about. Count 1, murder. Count 2, murder. They are both called murder, but they have different elements, different things to look at. Count 1 of murder is for purposely causing the death of Emily Noble. And you heard the definition of purpose. Purposely is when it's your specific intention to cause a certain result. And what do you have that reflects on purpose? Dr. Smock tells you what it takes to strangle someone to death. It's not an accident. It's not a brief process. In order to strangle someone to death, you must maintain continuous pressure for somewhere between a minute and 2 minutes to cause death. That's purpose, ladies and gentlemen. It says the purpose with which a person does an act is known only to him unless he expresses it to others or indicates it by his conduct. Anyone who is causing a death by manual strangulation must maintain that pressure for more than a minute. That's done purposely. Count 2, the other murder statute, doesn't require that proof of purpose. It requires proof that the death was the proximate cause of a felonious assault that you'll see in count 3. So 2 and 3 go together. If you find the defendant is guilty of felonious assault for knowingly causing serious physical harm, then you have to look and see if that serious physical harm led to death. That's what the difference is between count 1 murder and count 2 murder. And again, you heard the testimony of Dr. Smock about the dangers of strangulation, about what happens as you put your hands or arm around someone's neck and squeeze. What happens to blood flow? What happens to oxygen flow? What happens with risks of hospitalization and death? That's serious physical harm. So even if you weren't convinced that this is a purposeful murder, if you're convinced the defendant knowingly caused serious physical harm to Emily Noble, and that as a result of that offense, as a proximate result, she died, that's still murder and counting. Now, ladies and gentlemen, we put together the board. We put together the outside of the pieces of the puzzle. This is not suicide. And now I ask you to look at the other pieces. Look at the other evidence now through that lens. Now that you know this is not suicide, let's look at the other pieces. This is a staged suicide scene. Who on planet Earth would have an incentive to stage a suicide other than the defendant?
How the fuck would you know you didn't investigate it?
Random.
Nobody. Not one other person. They went to another person. They followed those dogs. Those dogs followed her scent to another person's house. They never even investigated that guy. They never did a criminal background check on that guy.
True story.
If you're not going to develop, if you don't ask any questions, if you don't look for anybody else, that statement doesn't fucking make any sense.
Yeah.
Who else would do it, right? Who else would do it but Matt? How the fuck? Who knows? So it's like I'm the only person that she knew in her life. Dude, she lived there her whole life. She had ex-boyfriends. She had people that knew her, that were close by, that might have not wanted her to be saying what she was saying at that time because of her abuse when she was young. They didn't even want you to know that she was abused. When her mother died, she started talking about her abuse. That's what they do. A lot of women that are victims of abuse, they wait for the parents to die because they don't want to cause their parents pain. As soon as her mother died, read the book, by the way. You should read the book. She started talking about physical abuse, sexual abuse that she was a victim of when she was a kid. Did you even fucking talk to that man? Did you call him? He lives within an hour. They didn't even call him. Nothing.
A good plug of the book.
So the answer to your question, Sleeper, you fucking liar, is we don't know who else would want to do this to Emily because you didn't investigate, and neither did the scrubs. Because you're fucking stupid, or you're corrupt, or I don't know what. You got tunnel vision because you're not good at what you do.
Unknown suspect, the Westerville strangler who's manually strangling women in the woods, wouldn't take the time, the effort, the care to stage a suicide. What would be the point? Who else, a random other individual, would have the tools and the items nearby or ready at hand in order to stage a suicide? The only person that would have any incentive to do that is the defendant. But it's not just staging the scene in the woods. I'd submit to you the evidence shows he was staging the scene the whole time. What do I mean? The defense version of events is that his wife, sometime after 1:30 in the morning, because that's when he saw her when he went to the other room, had to get up and go hang herself. Now, what do you need first? You need an opportunity for your wife to get up and leave the house without you knowing about it. Right? If you're awake, she couldn't have left without you knowing. So what's he say? Well, I went to sleep in the other room. What's he say? I took a sleeping pill. And he texted that even to a friend of his. Oh, I'm about to be out. I took my pill. And then he says he slept in unusually or abnormally late. How convenient. How convenient that the one day you sleep in is the day that your wife decides to get up in the morning and wander off into the woods and hang herself. So he's staging that scene with the text message he sends to his friend, and he's staging that scene with his story about
what's the sleeping pill
know
about?
what happened.
Why did he mention the sleeping pill? What the fuck does that have to do with anything? It's filler. It's garbage.
Been early in the morning with my wife because I was sleeping later than I normally do. What else do you need? You can't know where your wife is when you wake up. They live in an 800 or 900 square foot condo. You saw how small it is. You wake up in the morning, you go to the bathroom, look out the door, oh, wait, my wife's not here. Well, no, that's not the testimony. What's he tell you that he did? What's he tell you? I woke up and I was laying in bed, and instead of getting off the couch and talking to my wife about our plans for the day, I texted her, are we going to this party or what? In an 800 square foot condo? Hey, are we going to this party or what?
What's your point,
wants to do?
Sleeper?
Hits that Find My iPhone app, right? Because it'll give you, look, now when I pull out my phone records, if anybody ever looks at it, see, I sent her this text. I didn't know where she was, and I did Find My iPhone.
Either that or I just used it to try to
But you
find
still
out
never
where
get-
she was. Like everybody fucking else does, man. Everyone uses their texts their. We've been through this, right? Who doesn't text their fucking whoever when you're in the house?
Yeah, no, we went through this early on. Yeah, but you're right. Everyone would.
This is final argument, Dylan. This is his case. He's
Yeah.
saying part of the reason why you should believe that I murdered my wife is that nobody would ever text anybody in a condo that's our size. That's his evidence.
Yeah. Yeah, I know. It's
bullshit.
ridiculous. It's ridiculous. Yeah. Right.
It's up. He still doesn't walk around. 3 hours later, he texts to this phone that he knows he's got no response on. That he knows is sitting in the house. I guess we aren't going. And what's he say about that in his interview? He says, "Oh, I guess we aren't going. Where are you?" Oh, well, I didn't say the "where are you" part. Yeah, he forgot that.
What does that mean? What does that mean?
Tries to leave
What the
a record.
fuck does that mean? I'm sorry.
A stage scene to say, look, hey, I was in this other room. I woke up at 11 something. I sent a text. I had to Find My iPhone. I had no idea where my wife was. What else do you need? You know that you staged a scene to look like suicide. You know that there's a cord. So Emily Noble, if she was going to go kill herself, what does she need to be looking for? Something to hang herself with. Right? My wife got up, wandered off in the woods. I know that I've staged it to look like suicide. I know that she's hanging by a cord. What does she need? She needs to have found a cord. What's the defendant draw Officer Hollis's attention to? Where's he take him? Right into the garage. And what's he point out? An origin extension cord. And he says, this is out of place. This isn't where it's supposed to be. This used to be here. Watch it again in the body cam. Officer Hollis immediately says, can she even reach that? Watch the defendant is how he has to reach to get that cord off that hook.
He's
He
saying
says, I didn't do it.
that the cord was too high for Emily to get. So it couldn't have been her to get the cord. It had to have been me. Emily had footstools in every. You saw that. You saw our condo. It was spotless. She had footstools in every room. She had nice footstools, like these little footstools that were made out of wood that were handcrafted. They have pictures of them. They saw them. He knows that. But he, in final argument, is telling you part of the reason that you should think I killed my wife is because she wouldn't have been able to reach that cord. It was too high up for her to reach. This is fucking evidence to this man. I think they blew it on purpose. It's too far down the rabbit hole. There's no way that they put this case together as much money and time and public awareness of what was going on, and was like, this is the stuff that's going to work. How could you? Somebody help me. How would you, if you're putting a case together, would you use evidence like that in final argument to say, hey, this dude killed his wife, that Emily couldn't have reached that cord? It just, I don't get it. This is the most important part of the trial. Well, second most important. The most important is what this Corey guy is going to do, which he gets final argument. And they should have had him do final argument. I don't know why they didn't. You know what I mean? Like there's one more after this one. I don't know. Tell me, help me. Mighty Meat, help me. What the fuck are they doing?
You have to take into account that most people are kind of dumb. Like a good portion of people are kind of dumb. And they get away with this shit more often than not.
I feel so
that's
sorry for those people, man. I just
that's why they can put garbage up, man, because they get away with it.
Yeah. It's not new.
Right.
That's what we're saying. It happens every trial. Well, not every trial, but it happens a lot.
Mm-hmm.
I mean, I can't. It's because my perception is so whacked out now. You're telling me that the part of the evidence that we're supposed to use to convict this man is that Emily couldn't have reached that cord. It's too high up. What the fuck?
I've seen dumber shit, man.
Yeah.
Like, I mean,
I'll have to believe you, man.
Whatever they can.
Could
They
you
use
imagine
whatever they
sitting
can.
in prison, on death row? Imagine, and going through your case and reading that shit, and this is the shit that they convicted me with, and what hell that would be for those people. Why isn't anybody helping them? You know, it's like, why doesn't someone point this out? Oh, Go ahead. I'm sorry.
No, I know.
I didn't move this. But you know what we do know? He was moving things right in that area, even while law enforcement was at the scene. Even after they'd already responded, even after he's already trying to talk to them about what happened, supposedly to his wife. That cooler is moved. There is now a flashlight there. And it isn't just that he moved it. It's that he, at the end, Officer Hollis and the defendant are standing out in the driveway. And he says, maybe I'm crazy, but you just got to come look at this. He leads him right there. He wants Officer Hollis to see it. They look, here's this orange cord. My wife must have been looking for something to hang herself. But we know he's the one moving things around that area. And it's not just the cooler. He even says, watch it. He even says, he shakes it, wobbles the cooler a little bit. He says, oh, even this isn't where it should be. Or she wouldn't like that. And he's the one that moved it. So, ladies and gentlemen, he keeps staging the scene throughout.
We got proof that the cord
What
was
else?
on top of the cooler when Hollis first walks through my garage. It's there. Then later on, an hour later, he walks through the garage again. The cord is still on the cooler. The cooler's been moved over because I moved it. That doesn't mean I moved the cord, and they try to make it look like I did. That would be big if I'd moved that cord and then brought attention to it. They have no proof that I moved that cord. I just moved the cooler. It's weak sauce, is what it is. Weak.
Important. When was the last time Emily Noble was seen? Here's the testimony of John Kramer. John Kramer said when he first saw law enforcement, after he brought his dad home that he was taking care of, he sees the officer there and he says, I saw Emily Noble on the morning of May 25th. And he tells you he goes inside, gets his dad situated, and immediately comes back out and says he's not sure. You heard that.
And why did they make the statement? Then why did they come out Tuesday, the next day, and tell everybody with their press release that Kramer saw her on Monday? If Monday, it's Tuesday now. If Monday, he immediately came out and said, "Hey, I don't know whether I saw her today or yesterday," because he didn't. He didn't fucking change the story on Tuesday. That they wouldn't have released. They wouldn't have told everybody that she was seen on Monday, in that press brief. And of course, Sunday we weren't there. So even if he did say it, eventually he does. He says, "Hey, I don't know whether it was today or yesterday. Yesterday we weren't home." So
he told that to law enforcement later. And he told you that from the witness stand. And this isn't a situation that a year and a half or 2 years later, he's changed his mind about what he saw. He told them that immediately, that he wasn't certain.
Lie.
And how do you know that? How do you know that John Kramer had already said that right away?
How?
Because it's in the interview with the defendant. In the interview with the defendant, the detective says that no, the neighbor's not sure he saw her that morning. And what is the defendant's immediate response? Not concerned for his wife.
How does this prove that the dude
Not
didn't
wondering
say
what
it
that
on
might mean
Monday?
for where she is.
How does that prove that he said it on Monday? How does that prove that Kramer said what they're saying he said on Monday? That he came out and recanted. He said, "You know how we know he came out and recanted on that Monday?" And then he starts talking about this. It's a segue. It's bullshit. He's bullshitting you. He's trying to change the subject. It's a salesman play. This is easy shit. I'm sorry.
So that makes it look bad for me, I guess. Right. Because he was hoping to hang his hat on the fact that somebody saw Emily or thinks they saw Emily after he killed her.
So that's what I would say. I would say that to them. If I thought, oh my God, I got so lucky. Kramer's telling everybody he saw her Monday, 2 days ago. This is on Wednesday. They're saying that I said this. So there I am. And I'm like, after they say, he changed his mind. He's saying he didn't see her on Monday. So that you think that if I did this, that's what I would say to them? That, oh my God, this doesn't look good for me. Give me a break.
Submit to you the timelines of the phones conclusively prove that the defendant lied repeatedly to law enforcement about what happened. Repeatedly. Emily receives messages at 6:30 in the evening on the 24th that are not read until 4:40 p.m. the next day. There's nothing on Emily's phone to show any user-initiated activity after 7 p.m. on the 24th. Nothing. Until the defendant's on. The defendant's phone shows that after they came back from Uptown, out celebrating his wife's birthday, that he has a 34-minute phone conversation with a friend of his. A conversation that is never mentioned a single time in all of the different versions of events that he talks about.
Different versions of events.
We're told that, although the defendant says initially, I told Officer Hollis she wouldn't go out by herself at night. But then he thinks about it, and in his interview, he says, well, and he was like, does she ever go out at night, by herself? And I'm like, no, she doesn't. That's something that, but she does. At times now that I think about it, especially if she's got a little buzz and she's drinking, she'll get that, and she'll grab a flashlight, and she'll go on this walk and come back with the forge. Who told you that Emily Noble went for a walk that evening? He was sure about? John Kramer.
What did he say?
Emily Noble comes home and goes on a walk. Well, the defendant's on a
He
long
didn't
phone
say
call
that.
playing around on his phone.
He didn't say that. He's just making that up. Who said he saw her go for a walk on Sunday night, on Sunday evening? Did John Kramer say that? I don't remember that. He's just saying it. Wait till you hear what he's about to say now. Wait till you fucking hear this.
After he gets off that, there's a 40-minute gap of time where there's no activity on his phone.
40
Between
minutes
8:42 p.m. and 9:23
on
p.m.
Sunday night.
40-minute gap.
8:40 to 9:20.
Defendant knows
no, I'm not on my phone. Wait till you hear this, man.
the place where Emily goes to forage, knows where he can find her.
At night.
Ladies and gentlemen, I
Who
submit to you that's an
forages at
opportunity at that
night?
time for him to go leave the house and to go confront her in the woods. When the physical evidence shows she was struck in the face, causing fractures to her nose, and she was manually
Fractures.
strangled,
Multiple fractures.
causing
He's
full
lying.
fractures to her neck. After that time at 9:23, the defendant's phone screen turns on once or twice, and then between 9:45 p.m. and 1:11 in the morning, there's a 3-hour and 25-minute gap of time when there is no activity on his phone. Time to stage the scene.
Use your phone, guys. Always
the
be on
uncontroverted
your
evidence.
phone.
The uncontroverted evidence is that he is on his phone pretty much the entirety of the night. You'll have the timeline, look at it. And it's not just loading apps or doing other things, it's sending messages, orientation changes on the phone, plugging in the phone. He's on his phone all night.
He just told you that I
Till when?
murdered her between 8:40 and 9:20. There's 40 minutes on my phone where I'm not doing anything. And that would mean that she would have to be out, right? She would have had to have left, right? This is when is this? 8:40, right? 8:40. He said that John Kramer claimed that he saw her walking away, right? To go for a walk. What time? 8:00. So you're saying that Emily was gone for 40 minutes before I even left to go do this? Where she lived, where she was found, where she went, where they saying that she went, is a 3-minute walk from my house. 3 minutes. You're saying she went up there for fucking? Do you understand that? It doesn't make sense, right? Why would she be out there for that long, 40 minutes? It doesn't make any sense. And if you knew her walks, if you looked at her telephone records, how long would she go for these walks? They're saying that I went out there just because, and no one saw me. No one saw me leave. No one saw me come back. And I go back out there when I went to bed at 10, whatever it was. This 3 hours until I got up at 1 a.m. I went out there to stage the scene. I went back out there with a flashlight in the complete darkness after murdering my wife, dragging her into the fucking woods, running home, getting back on my fucking phone, right? Playing around with my phone for a little bit and then going back out there during this 3 hours. Nobody sees me. There's no evidence that it happened. That's an inference upon an inference upon an inference. It can't work. It doesn't work. Well, it didn't work in my case, but if it worked in your case, I feel awful for you because these people are criminals. He's a fucking criminal, man.
5:52 in the morning, he starts a YouTube app. And you'll see on the timeline that runs until 8:40 in the morning. 5:52, he's still awake, activating something on his phone. What happens 8 minutes later? Emily's alarm goes off. Do you think it's reasonable that the defendant, after being awake the entire night, loaded up YouTube at 5:52 and was totally asleep by 6? Remember, if Emily got up and she made the bed and made herself a drink and went off to commit suicide, she's got to be moving around sometime in that morning. And the defendant's awake right up until that time. What else is there, though? At 8:40 in the morning, the defendant's back on his phone. And what happened at 8:41? Amy Thomas sent a Facebook message in a chat that included both the defendant and Emily. I want you to think about that. Come back to that in a minute. Emily's device shows no user-initiated activity until 4:40 in the afternoon. None. The health data shows no movement. The phone doesn't go anywhere from the time when they get back from uptown in the night until 4:40 in the afternoon. And what do you remember happens at 4:40? How do you know that all this stuff in the timeline is what it says it is? Messages that Emily Noble received in the evening of May 24th were not read, did not show up as read on the phone until 4:40 in the afternoon the next day. What happens at that time? We know the defendant says the phone has been there. His wife has not been there. At this point, he's allegedly searched around. At this point, he's the one on her phone. And if you go into the timeline and look at 4:41 in the afternoon on the 25th, the SMS app, the text messaging app, is activated on Emily's phone.
So
That's how
what?
those messages show up red. It wasn't because of anything that Emily Noble did. It was because of the defendant. And what else
Yeah,
is important
so I
about
picked
that?
her phone up at 4 in the afternoon.
This
So
Facebook
what?
message. Remember, the defendant, here's another thing he tries to latch onto. Oh, Amy Thomas says the Facebook message that I sent shows that it was viewed by both of you. It was viewed by Emily and the defendant. Right? The
I
defendant
didn't
says,
touch that phone.
and she
I
must
didn't
have been
answer
alive
that.
8:40 in the morning. Now remember,
She
to
an-
be on her phone.
She was there in the morning. She checked that message at like 8 in the morning. Or I forget it was early. I didn't touch that phone. I was in my room. I was in Joey's room, chilling. She was there. Kramer saw her leave between 9 and 10. She was home. She was a butterfly. She was a butterfly around the house. She didn't make any noise, man. Read the book. Read the fucking book. This guy's telling you the truth, yeah. Yeah. Yeah, I checked your phone at 4 in the afternoon. So what's your fucking point? I don't get it. Why is that evidence that I murdered my wife? Please, someone tell me. Someone fucking tell me why I'm broke. Why I'm fucking homeless. Because of this fucking asshole.
Doesn't move, it doesn't leave the house, that would mean Emily Noble would have to be at home at 8:40 in the morning. And because there's a bunch of user activity again starting at 8:40 on the defendant's phone, the defendant would have to be awake too. So there goes I was sleeping in the other room and don't know anything about my wife getting up and leaving the house. But more importantly than that, look at the timeline. That Facebook Messenger app on Emily's phone is not activated until late in the afternoon when the defendant gets on the phone, goes into Facebook Messenger, and sends a message to the guy whose house they were supposed to be at on Memorial Day.
So?
That's
So
when
what?
that message shows up red. Not because of anything Emily Noble did. Look at the phone. The Facebook app flicks on when you receive a message, but it doesn't show any other user-initiated activity.
Yeah,
And you
it
heard
was
that
me that
testimony
picked up
from
the
cell
phone at
forensic
4. I was looking for
specialist.
it. So?
The only
I don't
time that app
understand
is open and manipulated and a message is sent is when the defendant's on the phone. That's not evidence that Emily was alive that morning. Ladies and gentlemen, look at the other statements of the defendant. Again, I would submit to you, know that he's lying to law enforcement based on what is on the phones because it does not match his story. Defendant tells you they were in uptown, they came home, and they made love. So he tells the officer. So he wants people to believe.
Is that what I said? I told Officer Hollis that I
What's he
made
saying on that
love?
signal app?
We made love? Really? Let's see what his point is. I don't even know what it is. Go ahead.
What's he saying in that chat to his buddy? 2
Oh.
weeks before this. 2 weeks. My marriage is over. We don't fuck anymore. 2 weeks prior, he's saying his marriage is over.
So how does
They
that?
don't have sex.
How does
He
that?
wants the officer to
Me
believe,
telling
oh,
my
well,
friend
I'm
2
telling
weeks
you.
prior that we don't fuck anymore, but on her birthday we fucked. How is that a lie? How is that evidence that I killed my wife? Explain it to me. You know what it is? It's an inconsistency or some sort of weirdness that they get trained to bring up at trials. It doesn't mean a fucking thing. What, you can't say to your buddy 2 weeks prior, hey man, me and my wife, we don't fuck anymore. And then 2 weeks later you fuck your wife. That's fucking unusual to you? It's fucking nonsense. It's fucking nonsense.
Had a good time, came back, had sex. What's he saying to Officer Hollis? Again, love the body cam. We came back, went to sleep in our bed. Our bed. Really? You ever called the bed that you sleep in with your spouse? Somebody else's?
That's
Like
fucking
yours and
evidence
ours?
to him that I murdered Emily.
I'll tell you, how else do you know you sleep in that other room? How do you know?
Her bed. I mean,
Got
our
a
bed.
blanket in there.
Oh, I'm sorry.
The hamper
That's
for his
evidence.
dirty clothes are in that bathroom, not over in the master bedroom. In fact, go back when you listen to his interview. He refers to that as the master bedroom. Her
So?
bedroom.
So?
Ladies and gentlemen,
Because I keep my laundry
Some
in my
TV evidence
fucking
is clear.
bedroom? That's evidence that I keep laundry in a separate bathroom. That I kept laundry in Joey's room and not her room. That's evidence to him that I killed my wife. Where the fuck? And then he doesn't even tell you why that's relevant. Does he tell you why that's relevant? That I keep my laundry in Joey's room. He doesn't even tell you what that means. You know why? Because he doesn't know. He's fucking stupid. He's
neither
lying.
one of them was ever in that
He's
bed
lying
on
to
the
you.
evening of May 24th. When Officer Hollis looks in there and he sees that the bed is made, that stands out to the officer. It ought to stand out to you too. Because either that bed is made because it was made in the morning of the 24th and nobody ever got back into it, or that bed is made because on the morning of May 25th, right before she decides to commit suicide, Emily Noble made the bed.
Does that sound like something that's abnormal?
That's ridiculous.
To a woman that's
No one
that
ever
tidy,
got into that
you're
bed,
going to
did he?
say that's ridiculous. That a woman that was as tidy as Emily was wouldn't make her bed. Guys, listen to what I'm saying to you. Evidence that I killed my wife was that suicidal people don't make their beds before they commit suicide. That's evidence. I don't know what I don't know.
Ladies and gentlemen, what else do I want you to focus on and think about? The defendant's behavior shows that he knows she's dead. He knows Emily's dead. What's he do? First of all, you hear testimony from John Kramer that he's smoking in the house. He's smoking in the house. That Emily would never allow that. Now, you heard a lot of questions about, can you see ashtrays on these different photos or anything else? You know what I submit to you that shows? The lack of those formal ashtrays is that people didn't smoke in that condo. They did not. But that was routine. It was not a routine practice to smoke in that house.
So
Well,
just
there's no
because
ashtray in this
John
picture, no ashtray
Kramer
in this
said I
picture.
was
Well, guess what?
smoking in the
There's a bunch
house,
of
I'm
empty
smoking in the
beer
house.
cans.
Just because there would have been people, there was people everywhere. They would have noticed. Other people would have noticed. Wow, man, what are you doing smoking in the house? Her family, her friends, my family, the police. Did anybody else see me smoking in the house on the 25th? Just John Kramer, just Mr. PI himself, Mr. Brainiac, fucking from across the street. He happened to notice. He didn't even see it. He smelt it. Fuck, give me a break. That's evidence. If I was smoking in the condo on the 25th, they would have fucking paraded everybody up there and they would have asked every one of those people. The last thing they would have asked, hey, was Matt smoking in the condo? They would have said, yeah. But they didn't. One fucking guy says it. John Kramer. John Kramer was the last person to see Emily alive. Period. That's it. That's why he said what he was saying. He got nervous.
There's a sink, a trash can. I mean, let's not pretend that the only thing you could possibly ash a cigarette into is a real ashtray. What else does he do? He tells you that he knows she's dead. Ladies and gentlemen, he's asked to rate his marriage on a scale of 1 to 10 over the last 6 months. And he says it's an 8. And he says, well, there's some old texts or maybe we're about whatever, but this whole Corona thing really brought us closer together. And without any other question, the question was, rate your marriage on a 1 to 10. I did not hurt my wife. I did not hurt my wife. I loved her. May 27th. May 27th.
What's that got to do with the rating my marriage at 8? What does it
If
mean?
your loved one is missing,
Rate your marriage. He said it was an 8. That's evidence? Well, why is it evidence? He doesn't say anything about it. It's filler. It's bullshit. And then what's he talk about?
if you don't know where they are, if you're trying to find them, how would you ever be referring to them in the past tense after such a short period of time? And he does it in other places too. Oh, she loved me. He talks about her in the past tense because he knows she's dead. And one other thing about his behavior on the 24th. Ladies and gentlemen, I ask you to put yourself in these shoes for a minute. You wake up, your spouse is gone. You don't know where they are. You remain calm for a while. You see what's going on. You don't know. You wait. And the minutes and the hours pass by. you don't hear from them or see them. And you know a place, a short walk from your residence, where they like to go. And you don't ever walk it? You don't ever go out there yourself? The defendant wants you to believe that he checked to see if his guns were there, that he checked up into the attic, that he's looking all over the house, trying to see where his wife could be. He knows right when Officer Hall shows up. He talks about this walking path that they go on. And yet at no point in the 6 hours, even by his own version of events, he's awake before he calls law enforcement or before he calls Celeste. He never goes and looks at the place where he thinks his wife might be.
There was no reason for me to think that she was there. I never once thought that she was there when it was going on. Not once did I ever think, hey, that's where she might be, ever. Nobody thought she was there. Especially after the cops fucking looked there. You know what I mean? On Tuesday. What the fuck?
One, that he can't be the one to find her. There is no other reason why you wouldn't go looking in a place where you think your loved one is after they've been missing all day.
Boy, he's a
It's
real
that close to your house.
certaintist, isn't he? He's so certain.
And then, ladies and gentlemen, I'd submit to you, he pretty much tells Westerville Police Department where she is. Let's be blunt. Makes the Westerville Police Department look pretty bad. Those initial days.
Because they are bad. Because they
Nobody
fucking
got in that
suck.
part of the woods where Emily
How the
Nobles
fuck
remains
did you
were
miss her?
It does. It looks pretty bad. But you know who it looks worse for? The defendant.
No, I don't.
The defendant, even on the knock and talk, when he goes out for a walk with the detectives, and he says, I don't know, you'd have to go in there to look. Not that I'm thinking she's in there. When he talks in his interview, what would Emily do? Well, she'd go into the woods and hang herself. What a lucky guess.
Or maybe she
What a
just
lucky
did.
guess. He gets where she'd be and how she'd do it. And remember, this isn't a suicide. This is a staged suicide. So how much even luckier would he have had to have guessed where she was and how she'd look if it was some other random stranger who had committed the murder?
And why would I beat her to death if that was me?
Ladies and
Why would I
defendant
bring them there
in his mess-
knowing that they were going to find her, and when they found her, have her with a fucking bruised, smashed in face? Like I fucking beat her to death. What good does that do me? If they would have found her on Tuesday when the dogs came, she wouldn't have had any bruising on her face. Her neck wouldn't have been broken in those 4 spots. The reason that this happened is because they missed her, and she was out there for so long, and they covered their ass. That's what they're doing. They're covering their ass. And this dude here, he doesn't give a fuck. It's just another case. People have already forgotten about this. They've gone on to the next thing. They don't care. It's about the money an investigation generates. Westerville has so much cash. Mighty Meat will back me up on this. They had too much money. So they had a caper. They literally were looking for murder when most police districts, jurisdictions don't even start looking for people. Looking for 14-year-old girls. They won't look for them. But they're looking for a 50-year-old woman who's been gone for fucking less than 24 hours. They're collecting DNA for fucking a murder case.
The whole thing seems it's not hard to believe that they are this bad. It's hard to I just don't even know, man. Like it's insane that this is what your taxes pay for. This is what your shit
your
pays for.
taxes pay for, Westerville. This is what you write that gross check for every fucking 6 months. That goes to people like him that don't give a fuck. If it happens to you, they're gonna do it. They can put a case on you. They're gonna, because they want it. They need that money. They want to spend that money. It's gross.
Mm-hmm.
Yeah. Right. Let's finish what he's about to say here, because we can go into this a bit more in detail again. Anyway,
Message said that his marriage is over. His son committed suicide. If Emily's leaving him, if he's getting kicked out, he's got nothing left.
What do you mean I got
Nowhere
nothing
else to
left?
go.
I got fucking $600,000 in the bank.
Ladies and
I
gentlemen,
just
there's one last thing I want you to think about. And that's the defendant's words in the last part of the interview with Westville Police Department.
I got no place else to go. Shut up.
What's he say? I know I did not hurt her. I didn't do anything to her. So the other thing that I can think of is that she did something to herself. I know I did not hurt her. I didn't do anything to her. So the only thing I can think of is
This was on Wednesday. If I would have set her up to look like a suicide, I would have been saying that on fucking Monday. It took 2 days. 2 days. Yeah, finally I'm like, yeah, she might have hurt herself, guys. I don't know. When she would talk about it, she would talk about hanging herself. That she would talk to me about. What the fuck is this man talking about?
Consider that statement in reverse. I submit to you that the evidence shows, beyond a reasonable doubt, she didn't do anything to herself. And I submit to you the evidence shows that the defendant did hurt her. That Emily Noble died of a manual strangulation. That her death was staged to look like a suicide. And the only person who would have done that is a defendant. And we respectfully ask you to return verdicts of guilty on all 3 counts.
Thank you, counsel. Please give your
I
attention
won't
to
say a
the-
thing during Diane's.
No,
I won't say a thing during Diane's deal. I'm gonna shut my mic off. Let her
No,
go.
fine. I mean, no, look, I just want to get that out of the way. I mean, you might alluded to it. There's a lot of stuff in this it happens in every trial. It's frustrating as hell. That's probably the most I've seen filler, though. If I'm being honest, I mean, there's a lot of filler in a lot of trials, but that was more filler than I anticipated.
He said what he was saying because he knows he's not going to get crossed and he can get away with it. They came up with that.
Yeah.
Well, she's going to explain it. The 40 minutes that I'm not on my phone, that's all they got. That's all they have.
Yeah. No, it's all fine. It's just more. My point, the thing more is, I think the jury would get a lot of this, as in, I think they would understand a lot of this because it is like even sitting here, it's a lot of it's, well, as everyone keeps saying, it's filler. It's filler. There's no evidence. And a lot of trials are like this, by the way, but I think this is the most filler I've ever seen.
Like I say, this happens in every trial. They're just so bad at it, and their case was so weak that it's very, very obvious. You know what I mean? So I mean, but it's every case, right? Every trial has this. Did he connect any dots for you? Any? What dots did he fill? He just came up with more questions for you, right? What do you mean he killed her at I thought he killed her in the condo. No, he killed her in the woods. I thought he killed her, what time did he kill her? Oh, he killed her between 8:40 and 9:20 on Sunday night. Well, didn't anybody fucking see her? I mean, what? How did he do it? What, did he run out there? Did he follow her up there? I mean, how the fuck did he do it? He just happened to. He just left and hoped that she was at this one spot that she goes to every once in a while. Oh, well, this guy's the luckiest fucking guy in the world.
Yeah, I mean, I'm interested to hear what Diane to say because I think it's look, let's listen to what Diane's going to say. Then
she gets most of the main points, but the points I'm talking about, she doesn't cover because it's just. I mean, you couldn't. She couldn't know. Just let her go. Yeah, I'm sorry.
No, it's fine. No, it's fine. It's your time. I'm just trying to go through it as we are going through it. I wanted to try and keep it as full as possible for that one, but I don't think there's anything believable in him. Like, genuinely, I don't think there's that much that was believable in his closing.
He finally told his theory about how it happened, where it happened.
Yeah, but it doesn't make sense. It goes back to what Connie said. It took 25 minutes to make a decision. You can see why. I mean, I know it's frustrating for you to go through all this again, but they had nothing. I think it's quite clear they had nothing.
Right.
They had nothing. And fucking Walmart Wolverines. Well, it could have been a murder or it could have been a suicide. Well, there's your reasonable doubt right there. Case over.
Right.
It's done.
Very good, Mighty Meat. Very good. I mean, okay, give him the murder. Give it to him. Whatever. Prove it was me.
Yeah.
How would you know?
Right.
No, I think it was very weak. I'm surprised it was that weak. Oh well, we still got more, so I'll keep reservations until we listen to Diane and the final.
Wait till you hear Corey. Oh my god.
Yeah, let's listen to him as well because it is important to listen to it all before you make that kind of a judgment. But so far, in my opinion, that's very, very weak. That's probably the weakest closing I've seen, to be quite honest with you. Right, let's listen to Diane Menage.
Whether Matt Moore killed that woman. The state of Ohio wants you, and you know what? We picked you because you were the right
Oh,
guy.
I mean, fuck me, what a start! What a start! That is a hell of a start. Anyway, I won't pause
Reminds me
anymore.
of Karen Reed.
Yeah, that's
He's
just a
pissed.
perfect
He's
start.
fucking
Yeah,
fired up, man.
let's rewind it a little bit. I missed a little second, I think, so I'll go back. When she gets, here we go, from here.
One day and go for the home run.
Your Honor, thank you. I want to be really clear about something. Really clear, because nothing can be more important. And what I'm about to say in the next 45 minutes or an hour is what I'm about to say right now. The state of Ohio started their closing argument saying there's two options, suicide and homicide. They just sat down and said that they've shown by a reasonable doubt that this was not a suicide. That is not what this case is about. This case is about whether Matt Moore killed that woman. The state of Ohio wants you, and you know what? We picked you because you were the right jury for this case, and you were smarter than this. They want you to go into that deliberation room and treat it like a movie or a puzzle, or I guess we're talking Unusual Suspects in books now. They want you to go into that jury room and talk about, did she kill herself or did somebody kill her? That's not what this case is. What you have to go into the deliberation room and discuss is the charges against Matt Moore, the elements of the offenses, and whether or not they have proved beyond a reasonable doubt, not suicide or homicide, that he killed her. The judge has read through the instructions. There is an incredibly important instruction that reads, you cannot stack an inference upon an inference. You can draw from one set of facts an inference. From the same set of facts, you could draw another inference. But you cannot draw an inference and an inference. And so what does it mean? Literally, 6 days of testimony, 7 today. It is, did she commit suicide? No, she didn't commit suicide. So she must have been killed. Well, if she was killed, it's Matt Moore. That's inference stacking, not supported by the evidence. I literally, as I sat there, listening to the close, and I recognize that these arguments are arguments, and so I'm going to say this. 24 years, over 150 jury trials, I've never had a harder closing argument than this, because honestly, most, I've got evidence to attack. This case is totally speculation. I watched that clock at 1:50 p.m. on August 25th, 2022. I remember telling you, jurors, that times were important in this case, and when I said that in voir dire, I had no idea how important. At 1:50 on August 25th, 2022, I heard, no, you heard, for the first time, that the state thinks Emily was killed in the woods. And if any one of you thought, when they heard that now he followed her on the walk, and you said to yourself, oh, so that's their theory? That's reasonable doubt. At 1:50 p.m., we heard that for the first time. Our justice system has to be better than this. And you know why? Let's go through it. And before, and you come to know me, I am passionate, but I am not passionate without a purpose. This inference stacking that I just talked about, it's speculation. And there is no question that the law says circumstantial and direct evidence are of equal weight. There is no question about that. But here is what is not evidence: speculation. We think he did this. We think he did that. Now we think she went for a walk and mad because of a text he sent on May 7th to his friend, that on May 24th, after they've had a nice day together, that he now is lurking and going and following her and killing her in the woods. That's not just one inference and upon an inference. It's probably 8 or 9 or 10. But it's speculation. Members of the jury, I remember when we did that voir dire so well, we talked about why we had to do voir dire. It's because not every juror is perfect for every case. We went back and forth, and we both asked you questions, and you saw us ask some people to leave because they weren't right for this case. But you were. You are smarter than to think a man could be convicted of murder based on speculation. In fact, I think the only thing that has been proven beyond a reasonable doubt is that they think he did it. For sure. Now that, for sure, they've proven that. But let's talk about what else they haven't proven. I want to go, and trust me, I'm not going to show you Defendant's Exhibit D again. I won't show you the map. Okay, I know we've had enough of the map, but I do want to talk to you just about why it's so important. The judge is going to, of course, you've read the instructions and you have them, and he's going to tell you that the state of Ohio doesn't have to prove the exact date, but generally around the date and time. But you know from the way that Matt Moore has been charged, and more specifically, you now know from their closing argument that What they're telling you is that he was killed on the 24th. That's what they just told you in their closing argument. Now, I realize that they're arguing, but they have burden. They just told you she went for that 8 p.m. walk with John Kramer and he kills her after that. Hold them to that. So the searches, why is it so important? Well, it's important because, well, first of all, if she's not in the woods on the 24th or 26th or 27th or 28th, first element of their case fails. And the judge is going to tell you, when you go back in the deliberation room, you look at each and every charge element by element. On or about May 25th and May 25th, did defendant Matheau Moore in Delaware County purposely cause the death of Emily Moore? They're numbered 1, 2, 3, 4, 5. If one of them fails, you're done. You don't even have to talk about it. So if the date fails, you're done. If identity fails, you're done. Identity being Matt Moore, you're done. If purpose fails, and I'm going to talk a lot about purpose, you're done. It's not that they have to prove all of them. Any of the elements fail, they're done. That's the law. So here's why the searches matter. If she's not in those woods on the 24th or 25th or 26th or 27th, you're done. 27th, there's a GPS on his car. I always want to talk about the transparency of things or lack thereof. I know you noticed it. It's like I have to bring up GPS with Detective Grubbs. Like, here's an investigative tool that you use to track my guy, and you don't even want to bring it up. You witnessed how many instances in this trial did the state of Ohio wait to see if I did my job? Not just the GPS, the counseling records, the osteopenia, well, the list goes on. Never bring up any of these things. They wait to see. What can we get away with? Is defense counsel good enough? So back to the searches. She's not there, the 24th, 25th, and let's talk about it. It's not just humans and dogs. No one sees her, no one smells her, but I want to just talk about this whole theory that they've put forth that it's just bad police work, that they didn't go into the woods. Members of the jury, you are smarter than that. And I remember I was talking to Sergeant Alloway. Do you remember the press conference? And he refreshed his recollection. It came back and told you all that the chief of police told Westerville community and the public at large, we searched that area 3 times with law enforcement and once with dogs. Nobody said the perimeter. And here's what else we know. If I'm Matt Moore, and I think that's the word, the main criminal mastermind, and I'm going to talk about whether Matt Moore is the main criminal mastermind in a second, he takes them to the exact area and says, this is where she forages. And then even the state of Ohio in their closing argument just now had to concede that, you know what he says? You might want to go in. That's a bad fact, right? And you know why he wouldn't want to go in? Is it because he doesn't want to find her? Actually, I agree with that. You know why he doesn't want to find her? Because 10 months earlier, his son was hanging from a tree in the woods. I wouldn't want to go in a wooded area either. Let's talk about motive. Judge, of course, has told you they don't need to prove motive. We talked about this in voir dire. Totally agree. That's the law. But what the law also says is that the absence of motive. That is, if you say, I just don't see a motive, is something you can consider when finding that he doesn't have the intent. So here's why it's important. Now, again, you notice, of course, that I had to bring up the other bank account, right? There was the one bank account, and then it's kind of like, let's see if Menashe can do her job. So now you know you've got the one bank account with 90 plus, that was a joint, and then, of course, there's the other bank account that's 90 plus. And then, of course, I had to bring out that there was life insurance, which my client never filed a claim against. So let's get rid of any thought that there was a money motivator. And then the bank accounts. They talked to you about those checks. Now, there's one person in this jury that thinks to themselves, what about those checks? What about those checks? The burden's here. So where's Arturo and where's Paul? But I also want to tell you about the checks. What's the expression? A slow walk? The check to Paul is dated May 5th. So that's incredibly relevant. And the check to Arturo isn't dated June 6th. So that's incredibly relevant. You have them in the bag. And if you wonder where they are, you clearly know that they have all the power in the world to issue subpoenas and get people in. And so just even by admitting those checks, it's like that expression that we all know when you just throw things up and you see what'll stick. So then back to the motive, or lack thereof. They presented 3 family friends, Amy, Sue, and Brandy. And I guess this is what the state calls part of the edge of their puzzle. Well, the friends were so close that they hadn't had contact with Emily since 2019. In fact, Sue was last called by Emily when Joey died, and she never even called her afterwards to check in on her. So I'll leave it to you as to the extent of that friendship. And of course, her sister testified. And it's so funny, too, about Matt doesn't go into the woods and search for her. And so that inference should lead you to the fact that he didn't want to find her, and that should lead you to the fact that he killed her. I remember asking Amy about the fact that she didn't come to Ohio and search for her sister was no indication of whether she loved her sister or not. And she said, that's right. Why is it okay for some and not for others? And the counseling records. They want to tell you that Emily was happy, she was foraging, eating plants, nettles, and so there's no way she could have committed suicide. This takes me back to my own name, when I told you that this is a case about common sense. When we talked about suicide in voir dire, and we talked about mental health. And I really mean this. We are all smart, and I know each and every one of you, truly. If mental health were that simple, we would live in a much different world. It's not. It is not that simple to say, they seem happy. It's just not. And in fact, we know that just from history, right? We know that Emily's first husband, you heard her sister testify that they seemed like two peas in a pod and that he killed himself. And it was a surprise to her, Emily. And so I want to just go to the counseling records. And I don't do this in any way to disparage. I do it because it is an inaccurate statement to say that Emily was happy eating plants.
You see the prosecutor, go back a few seconds. The minute she made that argument, look at his face.
And so I want to just go to the counseling records. And I don't
Sleeper.
do this in any way to disparage. I do it because it is an inaccurate statement
He's like, I'm
to say that Emily was happy and eating plants and would never have killed herself. Because the truth is, and you'll see in the counseling records, that Emily had a history of depression and anxiety, that she had struggled with prior loss and trauma. Look through the records and see how many times you see the word trauma and loss and grief and sadness. Also, with respect to motive, flip through all the records, and these are Emily's statements made to a therapist in a safe space, right? They're not text messages sent quickly when you're maybe having a beer in the middle of the night or you're talking to a guy and you're doing bro talk. This is what you say to your therapist, right? This is a safe place. The only thing she ever says about Matt in these records is that she's worried about his well-being because Matt's so depressed too after Joey's suicide. She never says, damn, Matt's mean to me, Matt hits me, I'm being abused, verbally, physically, nothing. And I ask you, these counseling records, you will have them back there. Defendants, notably, defendants exhibit S. Pass them around. Look at them. In fact, please, pass them around and look at them because the narrative of suicide wouldn't happen. She had told her friend she wouldn't kill herself. Well, that's a false narrative. And something else about that hit me. If suicide were that simple, right? If you knew when someone was going to commit suicide, by logic, wouldn't suicide not even exist? Because if you knew someone was going to hurt themselves, you'd stop them from hurting themselves. This is the thing about mental health. You don't see it coming, and nor does the person. And you know why these friends and family members had these conversations with Emily about whether she'd kill herself?
Like 10 minutes.
Ask yourself when you're back in mental liberation room, are these conversations you have with your friends? Or are these conversations, friend checks, that people were having with Emily because they thought she might kill herself? Because I can tell you, I don't ask my girlfriends at drinks, are you going to kill yourself? I would only ask that question to a girlfriend that I thought just might do that very thing. The text messages. I promise you that my closing will not be as long as a stack of paper. This is why I brought this stack back. 1 year of text messages between Matt and Emily Noble sits right here. This is what they give you. They give you this. They give you text messages from November of 21st. Hi, thank you. On the second page of that, he says, why does it bother you so much? Am I mean? Page 63, not mean, unintelligible. And read the rest of it, how they communicate with one another. Because I submit to you that when the state of Ohio tells you how couples act, right? Like how they told you how Matt should have acted when Emily went missing. We're smarter than that too. Every couple's different. Every couple's different. Every person's different. So to normalize certain behavior and to say, oh, well, if you woke up and you saw your spouse gone, the first thing you do would be to call 911. We're all different. And I bet if you look at these text messages, you might well think, I don't text like that with my spouse. Or you know what you might think is what I think is like, wow, is that enough? I better watch my texts, right? And then going to the next set of text messages from December, New Year's Eve, he says, I don't want to argue. If you don't have anything positive to say, keep it to yourself, please. And he's literally asking her, try and be positive. Read these text messages because they gave these to you. They gave these to you to prove motive. I submit that not only do they prove lack of motive, I want to go to this one, where he says the latest set of text messages, by the way, is from March. She kills herself in May. March. I'm not feeling very well today, Matt says. I'm just going to stay in here today. I don't feel like talking. Are we going to the party or what? That's the last set of text messages you have. Of all those, that's what you have. And with the fighting or the argument, I think John Kramer was right. He heard a lot of voices 2 weeks prior. And if none of us have ever not raised our voices inside of our houses with our partners, bless you. But every couple's different. And you know what John Kramer said that he didn't hear? Was any arguing on the 24th or 25th. And there was even a jury question where I got the dates wrong initially. Like I think I said the 25th and 26th. And one of you asked a great question. John Kramer, is your testimony still the same about not hearing any argument on the 24th or 25th? And he said yes. He heard no argument. And we know he saw and heard everything because he's right there. And he was what we call a nosy neighbor. He's right there. He heard or saw nothing. 50%, and this is common sense, of relationships end in divorce. And those that stay together, well, I submit that some of them shouldn't, and those that do probably argue every once in a while. Here's my point. When you look through these text messages with respect to divorce or not wanting to be together or those kind of things, the only time divorce is mentioned is when Matt says, if you want to divorce me, leave me. Just tell me. Never in here, and you heard me ask the detective, does he say, I hate you, I want you dead, I'm going to kill you, I will hurt you? Nothing. Please read them. The absence of motive can be used by you in your consideration about whether he is purpose. The house. Well, I guess now that there was all that evidence about the house, now we know from the closing that the state believes she's killed in the woods. And so the attic and the cars and the no trace and the no fiber and the no DNA and the no blood, I guess all of those now aren't as relevant. Still, though, relevant seems to be the fact that Matt is being seemingly prosecuted because of all of the interpretations of the ways he behaved. But he let the officers in, he gave them consent, he gave them phones, he gave them DNA, access to the attic, access to the house, all the things that Matt did. And you heard those women talk about how to get from one side of the foraging section to the other, they either had to crawl or they all got burrs. Remember that? And then you guys asked questions about scratches. Okay, well, of course, we know that they have Matt's shirt from that night. And we now know that they believe that he killed her when she went for a walk. Okay, so I guess we're drawing inferences. They come home from the bar. Emily changes to get ready for her walk because she's wearing her walking clothes. And then Matt follows her for an unknown reason. And we don't know if he's, according to the state's theory, changed his clothes or not, but we certainly know what he was wearing at the bar. They have that shirt. No burrs, no scratches, no rips, no blood. Remember that question about might you have a fracture in the nose if you have blood from a fracture in the nose? Nothing. And the shirt from the criminal mastermind is in the hamper. The hamper and still not washed. I want to just talk about the police story. It's one of those things that no matter how many times you say it, it doesn't make it true. No one else would do this. No one else would do this. Okay, well, no other suspects were ever developed. We know on the 25th, he's taken into the police station. He's asked to come down in the back of a cruiser, and you saw one of your exhibits is he was read his Miranda rights. Right? This is on the 27th of May. He's their guy. And in fact, they continued to work from May 25th all the way to June 17th of the following year to charge him. Because they kept just looking, until they finally found Dr. Smock, right? And Dr. Smock arrives in May. Because if all this evidence that they've given you is actually evidence, they charged him in June 2020. So the police work. There's no other suspect developed. And if their theory is he's the only one, well, of course we know that actually, based on the evidence, the last person to see Emily was John Kramer. We also know what are the odds that two sets of dogs almost 2 weeks apart, went to the same house after searching for scent. And I asked the detective, did you interview the man that lived in that house? Yes, we did. Where is he? What are the odds? And that was the purpose of my question about that was two different sets of dogs, one in May and one in June. And do you remember when Sergeant Alloway was up there? And I said, so the second set of dogs went up here? And Sergeant Alloway goes, actually, they went right back down to the house, the driveway where the first set of dogs went. Where is it? Where is that investigation? Well, we don't have it because of tunnel vision. Police officers ignored Emily's mental health history, her drinking. We know that she had the situation in 2017 where they found her in Westerville. They just ignore it. Just like they ignore, initially in this trial, they wanted to sell you on the narrative that Emily never left her house without the phone. How many times do we hear that? It's like, and then it takes me, Diane Nashi, like it's our burden. I have to bring the cell data out And I have to show you Mr. Marcus Defendant's exhibit thingy. She leaves the house all the time without the phone, particularly as of late. And let's just put aside the fact about the walk. Now that they say she took on the 24th, it seems like on the 24th she left without her phone too. And guess when else she left without her phone? The 22nd, because she knows we went foraging with Celeste. And here's why I mentioned this, and why I put together this demonstrative aid and cross Detective Grubbs on it. Because when you have tunnel vision, and you literally get rid of things that don't fit with your narrative, right? That's not fairness. That's not proof beyond reasonable doubt. Kind of another example of the tunnel vision was just today you hear Dr. Volte. He did that report. He went out to that scene twice for the Westerville Police Department. It was odd to me that the prosecutor was crossing him on using a 10-foot cord and was like, why didn't you use a 20-foot cord? Because your own police officers told them to use a 10-foot cord, And so they're crossing the expert that they got. And here's what's the whole value, if you will, of John Bolte, if nothing else. When was the next time you heard from anyone in this case after you wrote your report? It was me. Because they got the report, they got rid of Joe. Just like they got the report from University of Tennessee. Where's she? And here's what I want to say also about the cell data. And this is critical, and I know you didn't miss it, but I have to say it. John Kramer. It's an interesting thing, the phenomena of excusing some for inconsistencies, but never matter. Like, their witnesses sit up here and say, I need my report to refresh my recollection about dates. And we say, of course, dates are hard to remember. Matt gets something slightly wrong, and he's a killer. John Kramer, for the record, did not retract his testimony or his statement to police. What he said is he can't be positive. He's not positive now that he saw her on the morning of the 25th. That's what he said. That's what he said. And so how do we know? How do we know when John really did see her? Because if he didn't see her on the 25th, what he told you is he saw her the day before. So it takes me to get the location data up on the screen to show that Emily is in Butyl, Ohio, the day before at 9:39 a.m. Then I have to ask Detective Grubbs, how far is Butyl? Hour and a half each way. This is why it is dangerous for the state to have tunnel vision. I know they want John Kramer to see her on May 24th. I know they do. But guess what? John Kramer saw her on the 25th when she went for a walk. And he was the last person to see her. He was the last person to see her. We know that from the cell data. We know that from the cell data, that he saw her on the 25th. And now they want to say that he retracts that. Members of the jury? You need to look no further than Defendant's Exhibit G to know that is absolutely not true. Another Defendant's Exhibit. Westerville press release, released on May 26th. May 26th. Emily Noble, 52, was last seen around 9 a.m., Monday, May 25th. They just told you in their closing argument that John Kramer right away withdrew his statement. That's not true. Which is not true. It's not true. And you're smarter than that. And you know what else? I wrote down in the statement, God love the body cam. Couldn't agree more, but isn't it interesting that in their burden of proof, they didn't actually follow and give you the Hollis interview with John Kramer outside on the body cam? I know you're smart enough to notice that. They cut that out. Because remember, Hollis goes outside and interviews Kramer, and he comes back inside and tells Matt, the neighbor says he saw her between 9 and 10. And I'm going to show you that clip. I'm going to show you that clip. Where, if you gotta love the body cam, where is it? Show it to us, because it's your bird. All this stuff about staging. Staging, first of all, Dr. Smock. I think in closing they said that Dr. Smock is the most experienced or qualified expert that you heard from. I'm going to let that sit there. Judge is going to tell you that reasonable doubt is doubt based on reason and common sense, and it's the kind of doubt that you would rely and act upon in the most important of your affairs. Heather Garvin, when I asked Dr. Heather Garvin, who is a board-certified forensic anthropologist, how many citations or articles or literature did Dr. Smock put in his report? She said none. So I just compare this as an analogy. If you go to a doctor, and they say, you say, I got pain in my knee, and they say, let's open you up, do surgery. Don't you say, maybe we should take x-rays, maybe we should do a little investigation, maybe we should get a second opinion. Not with Dr. Smock, because he says, they say, those studies are meaningless. And then they spent all this time talking to you about how there isn't a study of a 100-pound woman with the bilateral fractures from a hanging. I mean, how much did we hear about that? Well, if that's the case, when you go back in the deliberation room, look through all these exhibits, and look your notes and check and see where is the article that a 100-pound woman with bilateral fractures died of manual strangulation. Where is that article? Or better yet, where is the article that says that can have a USB cord wrapped around my throat in a way that we don't really know. And then as I collapse and I decompose and my head drops from the decompression, that the ligature doesn't move, or that the weight of my head, 10 to 12 pounds, is my skull. Remember how much pressure you needed, right, to kill yourself. Less than 10 pounds. The skull alone is 12 to 10, or 10 to 12. And then I guess in closing, Mr. Sleeper said, Miss Menashe got on the ground and she didn't even know how to show you. I completely agree, because I have no idea. Who knows? He said in his closing argument, you probably, during the beginning of this trial, sat there and thought, what was going on? I submit to you, you're still sitting here thinking, what is going on? Who knows? We don't even know how the ligature was around her neck, because there are no photos. And they want to talk about this perimortem trauma. I'm going to go there for a second. We know that perimortem trauma is days, weeks, or months. Within that time frame is September. September is months. That's why it's so important. And here's what else you know. Pull that cord out. It's like this, 4 to 5 inches. It's like this long, which means that when Chad Holcomb went to cut it, he cut one side first, real close. Because you never heard him say, I cut both sides at the same time, or 2 of us cut. And what happens when one side gets cut, right? The weight of the branch deflects. And now we know 3 inches. Do you not think that the branch pulled her up? And then we had the man, Charlie Carlson, that said, I held on to her with, and that's why I said, put your hand up. And this isn't videoed or documented. We have nothing. We have nothing. And how many times do people say how fragile her bones were? Perimortem is within that month frame time. Now, again, I don't have a burden to prove that she killed herself. But that's the significance of the perimortem. And this is the stage. I'm just sorry, going back. Won't surprise you. Jump around. Please, this picture is everything. It's everything because this has all been made out to be so horrific, right? What really happened is Emily went to nature to find her peace. And you'll see that in the counseling records. That's where she found peace. She went there and she grabbed her ankles. You know why she grabbed her ankles? So that she wouldn't stop herself from killing herself. And that's what you do. That's what you do because you know that when you kill yourself, your natural instinct is going to be to stop it. That ankle is grabbed. And here's what else we know in terms of the mastermind criminal mind over here. There's alcohol in the water bottle. Her vape pen is in her left pocket. And a vape pen on her left side within her reach. Do you know what we do? What's common sense when we're in moments of real stress? We turn to our vices, right? We turn to our vices. And here's else what we do. So if we're going to kill ourselves, we don't want anyone to know. We don't take an orange cord in the garage because we know she's wearing leggings with pockets. We take something that fits in our pocket so that we can go on our walk with our water bottle and no one will think anything otherwise. And in fact, she was right because John Kramer saw her going for a walk and he didn't see anything abnormal. So I want to talk about the science and then just about Matt. The credibility or lack thereof is for your determination. Again, I can't say it enough. I feel like this whole trial, 40-some minutes of the prosecutor's closing argument was about how this isn't a suicide. We don't have a verdict. But with respect to your job as a juror, it's to determine the credibility of every witness. And the judge has already told you that you can believe, disbelieve any, all, or none of a witness's testimony. That's totally up to you as a juror. I submit to you why this is so important and why Dr. Garvin, not just because she was asked to do the work of reviewing Dr. Agnews' report, but why I went through the age and the ancestry and the other things, is because if someone isn't doing their work, best practices, according to what should be done in forensics, right, that goes to their credibility. That goes to the weight that you should give their testimony. And here's what we know about Dr. Agnews' report and the other experts in this case. We know that there's the Montgomery County Coroner's report, there's Dr. Agnews' report, there's Dr. Smock's report, and there's the death certificate.
Oh, sorry, Heinz, I just seen your message. You off now, yeah?
Who?
Doctor, I just seen you.
Yes. Sorry, I was just taken away by her closing arguments. It's brilliant, but yeah, I do have to run. I have to get ready to for the day tomorrow.
Yeah,
all right,
that's
Doc.
all good, man.
See you, man.
Catch you later, buddy. No worries. Take care of yourself, man. All right.
Next week, bro.
I appreciate you for bringing me on. Thank you so much. Sorry to leave early. But yeah, thank you again, and chat. It's good to see you guys again.
Thanks for contributing, Doctor. Appreciate it. Thank you.
Man,
Catch you in a bit,
always a
man.
pleasure. Always a pleasure.
All right,
I can't wait to see you again next time. But yeah, Miami, I hope you're still there.
He's
Have
around.
a good one.
Yeah,
Have a
I'm
good
still
one.
here. Take care, buddy.
You too. Bye-bye.
Ta-ra, mate.
Every single one of these, Dr. Smock, Montgomery County, and the death certificate relied on Dr. Agnew. They told you that. Every single one of these. And members of the jury, I know how annoying it can be. Sometimes my histrionics and my garbage in, garbage out, and my things. You know what? This is why I said it. This is why I said it in fourth year. This is garbage in, garbage out. You heard from a board-certified forensic anthropologist who said there are no perimortem fractures to the nose. None. With respect to the perimortem fracture to the hyoid and thyroid, she said that anthropologically, they appear perimortem. We don't know when those breaks happened, though. We don't know. And if we don't know and you don't know, that's reasonable doubt. And so here's the thing about garbage in, garbage out. If Agnew goes, they all go. And the judge is going to give you an incredibly important instruction about that. He's going to tell you about experts. Give me 1 second because I don't want to misstate it. Thought I highlighted it. He's going to tell you, members of the jury, it's similar to the instruction that you can believe, disbelieve any, all, or part of a witness's testimony, is that if you don't believe Agnew and the other experts relied upon that opinion, they all go. And John Bolte and Heather Garvin, we have no bird to call them. And I do want to address, in case a member of the jury goes in the back and says, well, Ms. Menashe in opening said that she was going to call some other witnesses. I don't have a bird. And there is no question that I stood up here in opening and said I was going to call other witnesses. But here's the thing. I didn't need to. I just didn't need to. It's not my burden. I don't need to assume a burden. Heather Garvin directly refuted Dr. Agnew and is much more experienced and qualified than Dr. Agnew. And they want to kind of dismiss the peroxide issue. Well, the bones were soaked in bleach. And we know that bleach weakens and weightens bones. And we know that the bones have perimortem trauma. We also know that the bones were moved everywhere. They were moved to the morgue, to a cooler, to the slab, to a cooler, to OSU. And now they're apparently sitting at OSU. And I do want to say, because I just want to say this about how Dr. Garvin didn't view the bones. You never heard any testimony that the state offered my expert to see the bones, or that they made the bones available to my expert. And if you're considering the fact that she didn't see the bones, I ask you to consider the absence of that evidence. Did they make them available? Let's talk lastly about Matt Moore. We heard a lot, I guess the usual suspects, he's a mastermind. He's the same guy, and we're not parents, we're siblings, and we're children, and he's the same guy that's writing out a statement and asks how you spell the word couch. He asked you to spell memorial. And Matt, I'm sorry, I don't mean
right.
to be disrespectful, but he's the same guy that reads while he's writing. When he's
Matt
writing,
can
he's
spell
reading while he's
couch.
writing. And we all know, as people that have been around children, what that means.
What's your
And
point?
he is clearly, right, not seemingly the most sophisticated person. You've heard him speak a number of times. He uses things like, well, I mean, she's okay for a crazy woman, right? Like these are the kind of expressions that he uses. It's the same man, though, that would be able to stage a scene, figure out to put the alcohol in the water bottle, put the vape pen next to her because she's left-hand dominant, would tie her shoes so tight that they wouldn't come off, would put her hair tie around her wrist.
They're all working
would
out,
take off
seemingly,
one of her
because
necklaces,
there was a
two,
conversation like,
which is
holy shit,
He's that same
Philadelphia's
guy.
at the promised land. We
I
got people
also
eating
just
dope.
ask you to think about one of the other things that you heard today from Dr. John Bolte. Because remember in the video how he tied the knot close to the branch, and then the basket slipped and the knot actually went tight? Look at those photos. Right? Look at those photos, because we know that the branch is taller than 6'3", 6'4". We know that. The cord is slung over the branch. It's not knotted on top.
I believe somebody you know
If you're
also
gonna
would like to
actually
talk about the
do
draft.
that,
Coach Sirianni's here.
6 feet tall, and
Yeah,
the branch is like
Howie,
right here.
first and foremost, would just
Not
like to
make
say
sure it stays
the
that way.
absolute honor working
Look at
with
that.
you.
What is that?
Yeah,
She's
best
flung it over.
GM in the business. There's no two ways
Just
about
screwing
that.
up the final
Dylan's
audio.
watching the Pat McAfee show. We can hear it.
With respect to his statements about I didn't do it, he was obviously in the back of the police cruiser being read as Miranda. I don't know if there's one of us that wouldn't say I didn't do it. They use the past tense in the word gone. I obviously cross-examined the detective on the word gone, and his apparent alleged inconsistencies. He's actually been completely consistent about the fact that they came home during these hours when he's now at the park allegedly killing her, that he was sleeping, that he got up about 1:31 to go pee, to go to the bathroom, and that he was on his phone intermittently the rest of the night. The cell data shows all that. So the time period they're using against him is the time period when he said he was sleeping, when most of us would be. You know that they were out drinking. It was her birthday, and they'd had a long day because they'd gone to Buchtel and then his father's house and then out to celebrate, and we're now home. It goes back to that kind of when Matt is slightly inconsistent, we convict him, or rather we want to convict him. When John Kramer's inconsistent, absolutely not here, but here he's truth-telling. When the detectives are inconsistent, we excuse the behavior. It just can't have it both ways. So I want to play a couple snippets. Well, first of all, before I do, I want you to remember this. The mastermind, showing you what's been marked as defendant's exhibit X1. Remember when he did this? Remember when he did this? and this. And then in this one, when he turns his hands over. And then in this one, when he looks him straight on so he can see his face. Now, as I close, I just want to say that there's a lot made of Matt's use of words or the controlling mastermind. But there's one thing that we all know, common sense tells us, is we can't control our spontaneous reactions to things. We see something, we react. Nobody's smart enough to be able to control that. So I want to play for you 2 clips. We're going to play the clip when Officer Hollis comes back in the house after having just interviewed John Kramer. Look at his reaction. Oops, I need volume.
All right. So we found a little bit of information. We still don't know where she is yet. Okay. Your neighbor saw her in the garage about between 9 and 10 a.m. this morning. Said she was just standing in the garage. When he was leaving, he saw her. She was just standing there. He said hello. She said hello. This morning. Yeah, around 9, 10 o'clock. He went about his business. 51. Okay.
He saw her. She's alive. I want to play the second clip. When Matt comes out of his house, and he thinks he sees Emily. And this is, of course, on the 25th when he's called 911.
Hey, how you doing? This her? Yeah. That's your wife? Oh. Okay. You look just like her for like a second. Okay. No, I'll try.
Look at how he was just for a second. I thought it was you. And you remember asking me to ask Celeste, you look like Emily W. And in that first video, he says, oh, thank you, right, with his hand. And in the second video, it's like the shock almost took him over and he put his hand on his stomach. Nobody's that smart. And not Emma. Nobody's that smart. Members of the jury, I just want to close. I know that the state will get up here and they'll have a significant amount of time to rebut what I just said. And that's the way the process works. Nothing they can say, though, will change the fact that what they've given you is pure speculation. And I've honestly, in all these years, I've never done a trial where the judge has allowed jurors to ask questions before. But as I was thinking about my closing and how I wanted to end it, I thought about my ask of you as a jury. I ask you that when you go into that room, you ask yourselves, whomever you pick as your foreperson, write down all the questions you still have. Right? All the questions you still have. Put them on the piece of papers like you did so diligently over the last 7 days and put them all in the middle of the table. Because that stack of questions, those questions that are unanswered, those are reasonable doubt. Thank you.
That was awesome. That was excellent.
Yeah, it's pretty good.
And also very short.
Yeah, half an hour.
But it was about an hour. But it was
Oh.
just less than an hour, just 58 minutes or something. But it was what was needed. She didn't need to drone on.
No.
Already.
Yeah, you're right. I think it gets to be a thing. The time becomes a thing. You know.
Well, look at this guy. He's on there now. How long is he going to be on there for?
You might want to not even watch it. it's garbage. No, no, watch it because it's.
No, we are going to watch it. I'm just looking. Yeah, hang on. He's got. I'm not.
This is the guy that told you to read a book backwards.
Yeah,
that's what he does. Wait to hear what he says here. This is the most important part of this trial. This is it. This is what the jurors are going to hear last, and they put this clown up there. You can't tell me something weird's going on, man.
He's 40 minutes. 40 minutes he does as well, which is a lot. Diane did 50 odd minutes, and he's done 40. Jimmy, that says a lot, I think.
Dude, wait till you hear what he says, man.
I can't wait. I can't wait. This is what we're here for. I can't wait to hear this bit. Right, let's go. Let's go. But yeah, hey, we can go on Minashi again, but incredible.
If you still think I'm guilty after that, you're just fucking stupid. I'm sorry.
She
just explained to you. I mean, how the fuck was I supposed to? She explained it. I mean,
you don't even have to explain anything, Matt. She did it for you. She nailed it. She absolutely nailed it, mate. Like I was expecting something good, but
she really, really, really paid attention. She remembered Paul and Art's name. She remembered everybody's name, dates. She remembered everything. She had the story down pat because it was all the truth. She didn't have to normally she probably has to do a little, wiggle here, wiggle there to try to get around some shit. She didn't have any wiggle. She didn't have to. It was easy. So
she was also very truthful. The way she just made fun of you that humanized you, that
Right.
you know, I think made you personable, and I don't think she was even lying. Do you know what I mean? She's just like, this
No.
guy, he hasn't got a fucking clue. No
You would
way
have
could
had
he
to
do a
have thought,
murder.
just put yourself in my shoes. If I had killed her, all of a sudden I'm seeing someone walk up the drive or the side of the house towards the house that could have been my wife, that I mistaken it for being my wife. Do you know what that would do to someone? Do you have any
Yeah.
idea how freaky that would be? You'd be shaking. You'd be nothing. I was normal as could be. Normal. I don't get where the people are saying that and then a guy that can't spell couch, right? The limited intelligence. Is going to be able to pull something like this off, you know? Just
I know I'm laughing, right? But that was funny when she said that. That was great. You must have been sat there going, "What the fuck?"
Right? No, she apologized. She's like, "Yeah, sorry, man." I was like, "Whatever." I don't care, whatever.
No, that was class. That humanized you. That made you personable, man. That was great by her to do that.
The last thing she put up there was that I would have had to have been
Nailed
some
it.
sort of to see Celeste and think it was Emily, and then switch. Oh, it's not. You know, you'd have to be such an actor. You'd have to be so cold and precise. And I'm a lazy hippie, bro. It just doesn't fit my personality. There's no way you can pull something like that off.
I thought the first video was better. I liked the first video when you just went, "Woof, relief."
Yeah. I mean, who can do that? I would have had to have been an actor, a thespian. You know, it just doesn't make sense.
No, I thought it was very, very good. Sorry, Mikey, what do you?
And the cops knew it. The cops fucking knew it. They saw it. They see it. They saw what they see what everybody else sees, but this is what they do to people. It's fucking criminal.
Mikey,
no, I mean, it just seems like, I don't know, like at this point, you have to think the prosecution is just going to stand up and say, you know what, we're good. Like, they know they're getting their ass kicked.
Yeah,
the looks on their faces when the camera passes, when she walks past them, they're all like looking at her.
But this goes, I'm not sure if you caught this, Mikey, today, but this goes back to what Sean was saying on stream and some others were saying in chat about this. Matt's a prime example of, you know, it's bogus, but they want to. Matt, we're not going into this now because you're going to go into this next week. But
okay,
just because I wanted to keep it next week. But the amount of money that Matt spent on this trial, I mean, they want to make him bankrupt, and that's what Sean was saying they're trying to do for Karen Reid because it's bogus. Do you know what I mean? What they do to Karen, it's quite similar, you know. So
it's about money. It always is, man.
Process is a punishment, and it always has been.
It is.
So.
But it's quite freaky to see the same thing happening to Karen as what's happening here with Matt. So, but again, we're going to it more deeply next week, Matt. Ronnie, who was this asking? Nikki said custody or bail. He was in custody for 15 months. 15 months. Yes, Ronnie, very passionate and very detailed. She was amazing, absolutely. Right, let's finish this bad boy here now. Then he's got about 40 minutes to go.
Corey.
But no, let's go into this guy. Before we play it, right, I want to ask you one question only, because obviously next week could be more question time. But what was your sense of, what were you think? Obviously, you're emotional there, Matt, but what was your thought process when Stan sat down? Right, I mean, do you remember how you felt after hearing all that?
Yeah, I wanted it to go on forever. I really did. I was just like, keep talking, Diane. Just keep talking, and then it ended. It's been so long, but I was worried, man. I was worried.
Yeah.
I was like, these people didn't need any evidence to arrest me or investigate me or anything, and they didn't even need any evidence to like take me to trial. And look, there's no evidence here.
Yeah,
it didn't matter. I was like,
no, fair.
Why would they find me innocent? And if they didn't, I just didn't know how people were thinking. By this time, I'm insane. I've lost my mind. So
no,
I couldn't. I wasn't thinking rationally. So, but yeah,
no, that's fair.
This was my last day night in jail was that night, and I was scared to death.
Spoiler for everybody. He's found innocent. Spoiler.
Yeah, nobody knew that.
Nobody knew that. Damn, man,
right.
Spoiled it. Can you imagine someone's been here for 25 weeks?
Yeah.
And then right now going, motherfucker, you put me through all this. anyway, let's go through it. Fuck.
Very welcome.
Now, ladies and gentlemen, I'm not going to stand up here for an hour, 45 minutes. I will try my best to make it short and sweet because I know as the last person that you're going to hear from, I'm also the last person you want to hear from because that means the case is over and you can go back and talk amongst yourself for the first time in this case. But I've been doing this for a long time, maybe not as long as opposing counsel. And when you get up in closing and you say, look over here, look over here, look up here, look down here. That's what that closing was. It wasn't a focus on the evidence that you actually heard from that witness stand. You see in all of these documents, this is the evidence. And that's what you are to render your verdict on, the evidence that you heard, the evidence that you saw, your judgments based on the credibility, your everyday tests that you use to determine the credibility of every witness. That's your job. That's what you render your verdict on. Now, counsel will hold up giant piles of paper and say, well, you don't know anything about this. Completely ignores the piles of paper here that will be littered on your table as you walk through all the facts and circumstances of this case. The piles of paper in your lap from all the notes you've taken over the last 2 weeks. That's the evidence. And that's what we're going to ask you to focus on when rendering your verdict in this case. Now, counsel got up here and started off by saying suicide versus homicide. That's what the state wants you to focus on. What she ignored or failed to explain is that the reason we want you to focus on those two elements is because those are the two arguments that have been made throughout the last 2 weeks. You have in your jury instructions a discussion about the facts, the elements of each of the crimes charged. You have part of your jury instruction a discussion about suicide because that's what's being argued in front of all of you over the last 2 weeks. So this case is about suicide versus homicide because if you find that Emily Noble did not commit suicide, or if you find that the defendant, Matheau Moore, committed the homicide, that's when we're going to actually reach that verdict. But the reason that's an important distinction to make is because if you don't find one, you find the other. This isn't an accident, as Mr. Sleeper said in the initial close. This isn't an accident where Emily was walking through the woods, tripped, and accidentally hung herself. The evidence is clear based on pictures that you've seen from the scene over the last 2 weeks, and it's clear from what you're going to be able to see when you go back during your deliberation. And so it is paramount to understand that difference. Now, again, the focus during the last close that you heard from the defendant is, again, let's ignore the state's experts. That Dr. Agnew's report leads to all these other reports, and so if Dr. Agnew's report is garbage, then the rest of them are garbage. You've heard that over and over again for the last week or so when we've been referencing Dr. Agnew's report. The one thing that's apparently, again, that you feel the need to discuss is that Dr. Garvin, the defense's own expert, agreed with the paramount parts of Dr. Agnew's report. So it's not garbage. It's not throw Agnew, and I apologize, you're not going to get as much theatrics out of me, and you haven't over the last 2 weeks. I'm not going to throw pages on the ground to emphasize my point. That's not me. But to suggest that Dr. Agnew's report is completely garbage, and so the rest of this is garbage, flies in the face of what the argument has been made over the last 48 hours, which is that, Agnew's report, which is that Dr. Garvin's opinion is the only one that matters here. But not only does Dr. Garvin, and you heard her testify, agree with Dr. Agnew's parts of the report, talking about perimortem fractures, bilateral fractures to the hyoid and the thyroid cartilage. That's what we're here for. That's the injury. That's what led to the death of Emily Noble. What you also heard from Dr. Garvin is that she agreed with portions of Dr. Smock's testimony. She admitted to you, yeah, I cited this study, but when asked about the specifics of that study that she based her entire opinion on when it relates to whether this could possibly be a suicide, she folded. You could tell from her body language as she sat in that chair, again, body language that you all saw and body language that you all should consider. She did this. She put her arms across one arm across the other arm. She shut down. It was difficult when answering questions. Mr. Sleeper had to ask specific questions, and then eventually she said, okay, I got these details, and it doesn't fit exactly what we have in this case. And then on redirect, all
body
of a sudden,
language.
arms are moved. She's turning her chair, speaking to you all directly.
What was that?
That's just body language. The guy wants you to use body language as evidence. Fucking, are you serious?
And again, these are credibility determinations that you're all to make, and that's your job. Dr. Garvin also said on the stand that she was looking for something to refute Dr. Smock. And I highlight that to you because that's very different than when she first started testifying. They said, well, you don't know what you're going to get. When someone contacts me, they don't know what kind of report they're going to get. It could be good, it could be bad, it could be otherwise. That's my job. It's very different than sitting there and telling you all that she was looking for something to refute Dr. Smock. And you ask yourself, well, why would she be looking, or why would the defense be looking to refute Dr. Smock? And I would submit to you that's because Dr. Smock told you exactly what happened in this case. Now, Dr. Smock, you'll have his report. He didn't cite to a whole bunch of studies. Dr. Garvin cited to a bunch of studies that we learned later on during examination were bunk, but Dr. Smock didn't list a whole bunch of studies in his report, but what did he do? He sat there, answered questions from counsel, cross-examination questions. She certainly asked some questions about his background, his experience. And he sat there and he told you that all these years of his experience, handling strangulation cases, he went through a CV, which is 50, 60, 70, 80 pages, as a lot of these CVs are. I would probably suggest you don't read all of those from front to back, but feel free. Dr. Smock sat there, looked at all of you, and explained to you what he found in this case. what Dr. Smock told you is that this was not a suicide. He explained to you why. He showed you and demonstrated in that chair the cord. It's not possible to cause these injuries. He demonstrated that to you. He said that the cord is about 1/4 of an inch in diameter, and that there's a space in between the two bones where the fractures are from, the hyoid up here. And he demonstrated how you could find it on yourself, the thyroid cartilage, and he explained that to you. He explained to you that the factors in this case, in Emily Noble's case, why we're all here, why we've been here for the last 2 weeks, point to this not being a suicide. Her weight, not possible. He explained that to you. That in his experience, over dozens of years, not possible. He explained to you that the ligature, again, not possible. He explained to you that all those factors that Dr. Garvin supposedly relied on in the study that she cited, those are factors that all weigh in favor that this is not possible. And he told you that not a single study in his research, his years and years of experience, ever found a situation where someone under 100 pounds presented with those 4 fractures: bilateral fractures of the hyoid, bilateral fractures of the thyroid cartilage. Now, although Dr. Garvin wanted to find something to refute Dr. Smock, I think it's clear from her testimony she didn't. She didn't. So not only did she tell you that was what she was trying to do, but she also admitted on the stand she wasn't able to. So we ask you to take that into consideration when judging the testimony of Dr. Smock and the testimony of Dr. Garvin. Now, you also heard testimony from Drs. Richmond, Dr. Hickman. They explained to you their portion of this case. You were just told on the closing of the defense that there are no pictures, nothing to suggest where the ligature was, whether there was a knot. And I would submit to you that's completely false. Look at the pictures. The Montgomery County autopsy pictures, they show you pictures of the neck area. They show you that the 2 cords that went under Emily Noble's neck were intertwined. One went off her back. You can see from the pictures where the cuts were made by BCI when they went out to the scene. And you can also see in the imaging that they did, exactly where those cords were. You also heard testimony from Dr. Hickman that there was no knot. So to suggest that there are no pictures, and there are a lot of pictures, is completely false. Look at the pictures. Look at all of them. From the ones that were taken on the scene, from the ones that were taken during the autopsy. And yes, you may have to look at multiple pictures from different points in time. I'll admit that. But do that. And what you'll find is it's clear how the ligature went around her neck. It's clear there was no knot. And the reason that's important is because, again, all of the studies, the study that Dr. Garvin cited to, the study that was shown by counsel during the questioning of Dr. Smock as well as Dr. Garvin, the factors in this specific case, the only factors that matter to you all, were not considered in those studies. The unrebutted testimony of Dr. Hickman and Dr. Richmond is that Emily Noble died of multiple injuries to the head and neck. Dr. Richmond told you about the hyoid bone and how at that point, that's when they transferred the body from transferred the body to Ohio State to continue to evaluate. And Dr. Hickman's testimony on the death certificate is that the death was caused due to manual strangulation. Something that he told you, he determined this was not a suicide a week or so after he initially reviewed items prior to receiving Dr. Smock's testimony. And it was not until later on when that official determination was made and he sat in that chair and explained to you the process, how that process played out. And that's what caused the delay in the time as opposed to just waiting for Dr. Smock's report. Ladies and gentlemen, those are some of the experts that you heard from. You are going to get and you have in your jury instructions that you are to review their testimony amongst yourselves. You determine credibility as you do with any other witness, and you assign the weight that you think is necessary based on all of those reviews. And I think it's clear that you should be putting weight on Dr. Smock's testimony. Dr. Smock, again, as Dr. Garvin agreed with, his testimony, sitting in that chair telling you that this is not possibly a suicide. Now, it's easy in this type of case over 2 weeks to jump up and down, lay on the ground, do all types of theatrics. And I would submit to you, ladies and gentlemen, that at the end of this case, regardless of the outcome, Emily Noble is gone. She's gone now. She was gone when the defendant called the police and said she was gone. She was gone when he reached out to her sister and said Emily Noble is gone, and she's gone today. This is a serious case, and I think that's demonstrated by the fact you heard 2 weeks of testimony. Now, making the distinction between suicide and homicide, as I mentioned, is extremely important. And as we diligently outlined in our first close and went through the evidence, and I'm not going to rehash that now, I think it's clear from the evidence, from the testimony of everyone that you heard from around Emily Noble's life, there's not a single shred of evidence whatsoever that suggests she would have committed suicide. Not only that, not a single shred of evidence that she would have committed suicide on that special day that she has between her and her sister. Where is it? It doesn't exist. Because that's not what happened in this case. What happened in this case is that the defendant, her husband, Matheau Moore, murdered her, killed her. And that is why she's gone. So let's talk about that. Now, again, you were shown a giant stack of documents and said, look at all these messages. And they just want to show you these little flimsy handful of messages. And I submit to you because those messages outline what's happening in that 6-month period prior to Emily being killed. But I'd submit to you when you review those messages leading up and just a few weeks before the defendant calls police, calls 911, 8 hours after he's awake, is that his words, "My marriage is over." What you'll also hear from the messages you heard from the testimony from Emily Noble is that "I'm not wearing my wedding rings." Now, I'd submit to you those are pretty important statements to consider when reviewing the other facts and circumstances of this case. Not the messages about maybe 8 months later, what do you want for dinner? 9 months later, I'm cooking dinner. Even 7 months later, what are we doing tomorrow? The statements that you were presented are statements that are directly related to this case, relevant to this case, what happened in this case. And that's why you should give it its due weight. Now, what counsel said towards the tail end of her closing argument is that Emily wanted to find peace in the woods and the forest, and that's what she did. Now, we'll talk a little bit more about some of the other facts and circumstances, but ladies and gentlemen, I submit to you that she couldn't find peace in the forest if she wanted to. She had no light source. She had nothing that could illuminate the area where she was found. And that brings me and want to draw your attention to the scene that was found. When you heard original statements made by Mr. Moore, he suggests, well, I left the room at 1:30, went to the bathroom, slept in the other room, and when I woke up the next morning, 10, 11 a.m., she was gone. Suggesting that Emily, at some point in the middle of the night, when it's dark out, early morning hours when it's dark out, went to this wooded area that you heard testimony from the 3 ladies that found her about how it's dark in there, can't see anything, and they explained to you what that looked like. You all were in the woods. You all saw the exact area where Emily was found. You were there in the middle of the afternoon. So you can discuss amongst yourselves if it was easy to see, if it was hard to see. It's different when you're standing on the street looking up at the sun than when you're 50 yards in, 50 feet in, 60 yards in, whatever the amount was in this wooded area. Not only that, but instead of being there at 2, 3, 4 o'clock in the afternoon, you have to think that according to the defendant's statement, it's either the middle of the night, early hours in the morning, and nothing was found. There's been a lot of discussion about water bottle, e-cigarettes. But the one thing you didn't hear is there was no cell phone, no flashlight, no other light source. And that's an important fact. The reason that's an important fact is because I'll agree with you, or I'll agree with counsel. Andy Moore's not a criminal mastermind. He messed up. He screwed up. And the reason we know that is from Officer Hollis's body cam. Now, when Mathew Moore murdered Emily in the woods, obviously he would have needed a light source, would have needed something to find his way out of the woods, to climb that real steep hill, trying to get up out of the woods, make his way back home. And unfortunately for him, the one thing he didn't leave behind, besides the water bottle and all the other things, was the light source. He took the flashlight home with him. And we know that because then when he called the next day, reported that Emily was missing, and was showing the officer and telling the officer this story, this storyline, the timeline that keeps changing every time he's asked about it. About 2 hours into that, during a time period that Officer Hollis testified he's out in his car, there's nobody else coming and going from the house other than the defendant. It's during that time period that a flashlight appears in the back of the garage. And again, that's the same area that now Mathew Moore is highlighting, saying, oh, look at this cord. This cord doesn't belong here. I might be crazy, but this cord doesn't belong here. And it's not only the fact that the flashlight is there, the cord is moved, but go back and watch that and go back and listen to what he says. It's not a situation where, oh, I was moving things around and I realized this didn't belong. This cord didn't belong. Officer Hollis specifically asked him, did you touch anything? Did you move anything? And Mathew Moore says, no. He didn't touch anything. He didn't move anything. Now, I would submit to you that that was one lie of many lies that occurred over the period that Officer Hollis was there and throughout this investigation. And the reason that is important, not only because I believe the evidence shows that it's a lie, but that's the information that the Westerville Police Department is getting in that moment. The information they're getting is the information that Mr. Moore is providing them. And counsel wants to make show of a press release that went out the next day and other information that Westerville Police may have gotten wrong, now looking back at it years later. But think about what Westerville Police is doing in that moment on the 25th, the 26th. They're looking for a missing person. The only information that is being provided to them at that time is information provided by Mr. Moore because he's the last one that saw her alive. So to suggest that, well, Westerville, they were just shoddy police work, they didn't know what they were doing, they got this time wrong, this date wrong in this press release, I'd submit to you that the information that they were working on to find Emily Noble alive was information that was provided by Mathew Moore. Now, you were also just shown a video of Mr. Moore's demeanor when he finds out information from Officer Hollis that the neighbor may have seen Emily that morning. And a lot's been made about the thumping of his chest, his excitement. And I ask you again, go back and watch the body cam. Closing argument is not evidence, just like closing argument for the defense is not evidence. The evidence is what you heard from that box, which you have in exhibits. Go back and watch that body cam. And think to yourself, what new information did Officer Hollis just provide the defendant? Nothing. Nothing was new. According to Matthew Moore's statement, he woke up at 1:30 in the morning, went in the other room, woke up around 10 or 11, and then Emily must have gotten up and left at that point. So think to yourself, why would now hearing that somebody else may have seen Emily get up that morning, the same thing that the defendant said, that's not new information? Is that the reaction
I
you
don't
would have
understand
if you
that
told
at
me
all.
you were right? Or is that the reaction that you give when you find out, well, I might get away with it? Somebody may have seen it this morning or thinks they saw it this morning.
Holy shit.
So go back and watch the body cam footage. Think about the timing. We talked about an opening that, again, you don't just fast forward to the end, see the ending, and make your decisions. You got to look at all of the pieces as they fit together. And so it's not only important to hear what the defendant said, but it's important to look at his demeanor, his body language, and how those actions, what is happening around that. And that's no different than the cell phone records. What's happening around that? What information do we have, or what information does police have up to that point? Does his reaction seem like it's towards something, new information that was given to him, or something different? And then going forward. So please diligently review that. Diligently review that timeline. And I submit to you that that's not the demeanor of someone that is excited, that maybe his wife left that morning. That's the information he gave police, but it's something different. You also heard that, or saw a video of Matheau Moore seeing Celeste Grown when she came to the scene, and Officer Hollis said, "Is that your wife?" And he, oh, thought that was her for a second. Again, ladies and gentlemen, is that someone that's got the reaction of, oh, maybe that's actually her? Or is that someone that acts like that they may have just seen a ghost? They see someone, it might look like his wife, he knows it's not her. If he was that worried about his wife coming home, he certainly would have spent the 10, 15 minutes to walk down the street to the walking path that she did regularly. But no, he didn't do that. He didn't do that either. So ask yourself, these are all pieces and things that are getting thrown around. Things that are, well, look at this over here, look at this over here. But it's important to look at them sequentially as they're happening. As Prosecutor Sleeper said, last week you may have been looking at pieces of evidence and thinking, how does this all tie together? And that's your job now as the jury. As any case, and I'm sure Ms. Menashe will agree that we, in our minds, have an idea of how a case should proceed, and we try to keep it as linear as possible, and sometimes that's just not possible. But the reliance is on the jurors to take notes, to speak amongst themselves. The reliance is on counsel to get up in closing and to tell you exactly what sequentially is happening. Now, ladies and gentlemen, what you'll see in this case, and it's been presented over the last 2 weeks, and you'll see when you review the evidence, is that, again, the defendant's not a mastermind. What you can see is something that you all have probably seen in your normal day-to-day lives, is that one lie leads to another lie, leads to another lie, leads to another lie. You can see that right away, again, in Officer House's body cam. The defendant comes up with a story about this beautiful day he spent with his wife the day before. And I want you to believe that she committed suicide that next morning. Spent this beautiful day with his wife. They had sex that night. He woke up at 1:30, and then the next day she was gone. Again, you see from the body cam that Officer House, who's been doing this for a long time, is seeing things that don't fit with what the defendant is saying. He looks in, sees that the bed is made, immediately says that, and you can see the reaction of the defendant. It's like, I just saw that. I just saw that. Thanks for pointing that out. She must have made the bed this morning.
What the fuck does that mean?
He goes in there, takes pictures during the search warrants, going on the body cam, you can see the bed, and we submit to you, it's clear that nobody slept in that bed.
Someone made it.
Another example of a lie. And fast forward, short period of time later with Officer Hollis in that same bedroom, Mr. Moore's now saying, well, she made the bed, but the pillows are out of sorts.
Who's 6 at night?
Must, the pillows don't make sense. Another lie. Sleeping pill. I took a sleeping pill, sending that to his friends, to Arturo, and text messages in the early hours of that night. And it's clear that from the phone records, which you'll have, and we ask you to review again, as painful as I'll admit it's painful, but please review those and looking at the timeline of all the events, that the defendant is clearly on his phone up till 4 in the morning.
So?
And then again at 8:30 in the morning. And the reason these details matter, details are important, because you have to compare that to the story that the defendant has been telling Officer House initially when he first came out. He keeps adding on to. He keeps going along. Adding different facts. The timing is all messed up. That he then in his interview with detectives is going through the timeline, and he immediately comes in and says, well, my time might be wrong, but here it is anyways. And when looking at the demeanor, and again, you ladies and gentlemen of the jury, your sole judges of credibility, look at the demeanor, use those everyday tests of truthfulness, the things you can do when you've got your 2 kids, if you have 2 kids telling you 2 different things, and you have to decide who's telling you the truth, use all those everyday tests. It's nothing special. What you can see in the defendant's interview is clear. The facts and circumstances that aren't an issue, that Emily Noble, Matheau Moore went to Butte, Ohio, went to a few restaurants in Uptown. Listen to his demeanor as he's telling that to detectives.
It's white fucking noise. You know what white noise is, Dylan? You ever heard that term? You know what Christopher Hitchens is?
Yeah.
You know the author Christopher Hitchens? He's from England. He coined this term white noise. That's what this is. He's not saying anything. Literally nothing. He hasn't said a fucking thing, but he keeps talking.
Let him.
Sleeping pill. Okay, sleeping pill. We'll connect the dot. No. You know? He's just cord. We'll connect the dot. Nothing. He's literally just talking. It's
it's great. It's great for you because he's fucking. It's yeah. Look, in a way, looking back, it's funny because it's great for you. This rubbish, you know.
But it's important. I don't know why people watch these if they want to try to improve their country or improve things, or they're just watching them for entertainment. Just know that these are the people that are running things. It's serious, and don't always. I mean, I always did. I always looked at people that were like arrested or on trial for something, and I always thought, yeah, they probably did it. You know, whatever. I'm telling you, they say that like 3-4%, 5% of people are innocent. I'm going 30% of people that are in prison for major crimes are innocent. They're just putting cases on people, man. It's money.
And then as soon as detectives start asking him about after they get home, that's when the timeline falls apart. That's when it's, well, it could have been this time, it could have been that time. Well, I don't remember. Could have been this, it could have been that. Go back and review that. You can see the clear change. Because instead of getting in there and telling the truth about what's happening, now he has to make sure that not only is he saying, but he has to remember what he said before that, and before that, and before that. And it's clear you can see that story change and continue to evolve. You can also see that when detectives ask Mr. Moore about his marriage. He talks about it being an 8 out of 10. And then when detectives start asking him about specific messages and we taking your wedding rings off, then all of a sudden it's, well, you know, there are ups and downs. Trust me, you wouldn't understand. Tomorrow everything would have been fine. Again, when talking about
10 pages,
that are not at the
10 pages out of 600 pages of text messaging that had, and out of those 10 pages, they weren't even arguments. You read those just that 10 pages, because the rest, there was nothing wrong with it. Who has a relationship like that? And this guy's going to be talking to the jury like this, like there's like I was lying about saying that my marriage was an 8. What more do you need to? I mean, they're liars, bro. This he knows I'm innocent. He's lying to the jury, trying to close the case. These are the people that we pay with our tax money, and they'll do it to you.
Discussing these things with officers, detectives, in a far different way when pressed on specific facts and circumstances in that time period where Emily is missing and where Emily was killed. There's a discussion about some of the searches that were done in this case as well. And I'd submit to you, ladies and gentlemen, that you did not hear a single shred of evidence from that witness stand, any of the documents, any search the defendant was involved in. Not prior to reporting her disappearance, that 6-hour window plus, where the defendant is sitting in that bedroom doing nothing except for being on his phone. Nothing during that, after the report to police, or any of the months after that.
He's lying.
You heard
they had
from various
a
witnesses.
GPS on my car. I was all over the place, bro. They know I was. They can just say things, and then when you're watching another trial, know that that's what they're doing. They're just saying things because they can get away with it. They know I was searched. I searched. We proved it. And we on Dylan's show, we had my brother on who testified that we were all over the place looking for a live person. Not a body. They were looking for a body. We searched. I searched more than Grubbs did. I mean, the police didn't even find her. Do you know the name of the group that came in? It's called Texas EquiSearch. Texas EquiSearch. That's their sole purpose is to look for corpses. They're a big deal. They're on other cases. They're all over the country. How'd they do? You know what I mean? How'd they fucking do? It's a scam. Texas EquiSearch, they don't even work. Neither do the dogs. Go ahead, man.
I'm only playing it forward because there's like 2 minutes left, 3 minutes left. That's the reason.
Talked about the fact that they went on 10 plus searches and had never met Emily in their life. And I ask you to consider that when looking at the other facts and circumstances. Why would the defendant not want to be involved in the searches? Why would the defendant, who's pretty clear initially to the officers and the detectives that you need to search this area. You need to look in this area. This is a walking path. You should look in that area. Why would you not want to be involved in that search? And why would you have not searched that area prior to calling law enforcement? Again, ladies and gentlemen, we're not asking you to use special tests. We're asking you to use your everyday experiences. Use your common sense and put yourself in that situation. What would you do? Your loved one is missing for 30 minutes and you don't expect it. Especially if you get up and you see wallets there, cell phones there, keys are there, cars there, and it looks like they just disappeared out of thin air. Do you wait 30 minutes before you do something? Do you wait an hour? Do you wait 6 hours before you even lift up a finger? Not until you call the friend, Celeste, who says, what are you doing? Call the police. Not until that happens do you eventually call police. You don't go on a walk in an area that you know she frequents. You don't want to go check to see if she trips, hurt herself and can't get up, hit her head, had another medical episode. You don't do that for someone that you're married to, someone that apparently you love. Ladies and gentlemen, use your common sense. The reason that man didn't go on any searches is because he could not be the one to find her. He couldn't. And why couldn't he be the one to find her? Because as he said in his interview, that would make him look bad. And I understand that was in a different context, but he knows.
Hey, Corey, if you hear this, fuck you, man.
I got lucky. Speaking of getting lucky, how lucky is the defendant that he points Westerville police to the exact area that she commits suicide? Of all the places, the eastern portion of those woods, anywhere, any of the walks that they would have gone on, somehow he knows that 4 months later, that's exactly where she's going to be found. As we put it in the first close, that makes Westerville Police Department look bad. They should have found her. That makes the defendant look far worse. He knew exactly where she was. And he knew exactly where she was because that's where he put her. That's where he killed her. That's where he strung her up to make it look like a suicide. And he knew exactly where she was until she was found in September. Ladies and gentlemen, not only that, but as we pointed out, as you've heard from the testimony, not only did the defendant not go on any searches, but while everybody else, people have never met Emily, law enforcement is diligently looking for her alive, because at this point it's a missing persons case, a day or two after the report. That's when the defendant is not only not searching, but then suggesting that he's not ready to find a body in the woods. He's giving an interview saying, I didn't kill my wife. He's giving an interview where he's saying, I loved her, speaking in the past tense. The only person that is thinking of Emily Noble in those days after her report of being missing, the only person that is suggesting she's already dead is that man sitting over there.
Grubbs told me she was dead
Ladies and
on
gentlemen, I submit to
Wednesday.
you that the reason he's the only person is because
They didn't see that part of the
after
they didn't show that part of my interrogation at trial. Was Grubbs in my face yelling at me, telling me that I killed Emily and that she was dead. They didn't get to see that part. I don't know why.
2 days after, up until the time in September when she was found, the only person that knew she was dead and murdered was that man because he did it. And that's the defendant, Matheau Moore. Ladies and gentlemen, please, I understand this is a long 2 weeks. I understand there's a lot of evidence and a lot of things for you to consider. Take your time, speak amongst yourself, walk through the evidence, walk through the timeline. The timing in this case is extremely important. We asked you to do that in opening, and I'm asking you to do that again. When counsel implored you to write down all your unanswered questions, fine, do that. But ask yourself, what are the questions that matter in this case? Is the question of, were there bubbles in the water bottle, or was it something else? Are there questions about whether her shoes were tied once or twice? Are those the questions that relate to the elements of the offense, which is your job to go through, the elements of the offenses? Those are the questions that matter. Those are the questions that Dr. Smock answered for you. Those are the questions that Dr. Agnew answered for you. And honestly, those are the questions that Dr. Garvin eventually answered for you. So ladies and gentlemen of the jury, please be diligent in your look through this evidence. And we are confident that after reviewing the evidence, the testimony of the last 2 weeks, you'll make the only finding in this case that the evidence supports. And that's a verdict of guilty on each count from you. Thank you.
Yeah, take your time, guys, because take at least 25 minutes. Take at least 25 minutes while you deliberate.
Yeah.
You had a long day
God,
today,
that
huh,
guy's such
Dylan?
an ass.
No, I had a long day today, yeah. But a good day, if you know what I mean. What were you saying, Mikey? Sorry, bud.
I said, God, that guy's such an like he did. He just stood up there and lied nonstop for what 45 minutes.
It would be compelling if he
he attempted to connect dots. They made these points. You know, they made weird things like he said her bed and then their bed, or you know, he say all these their points. They just didn't ever connect any dots. So I mean, at least in final argument, take an attempt. It would be insulting. I think the jurors were insulted. I really do. I think they were just like, I can't believe that we're even here. You know?
I got a couple of quick questions for you, right, before you go, Matt, right? I want to answer, right, so most questions we're going to ask next week, right? So if you've got questions, keep them to next week. We'll ask Matt everything. Matt's going to open the books. He's going to tell you everything. I think we know, we've gone through the trial. We know your thoughts in most things, but we don't know your thoughts about Diane, the process. There's a lot of stuff we don't know. But there's one question.
Yeah. Right, go ahead.
Well, there's one question here I want to ask, because I'll forget by next week, and it's a good question. Were you ever thinking of taking the stand?
Yes, all the way up until I said no.
Why did you...
I just wanted to tell my story. You have no idea. Like when I first got a lawyer, he's like, don't say anything to anybody. Don't say anything over the phone because they got you wired. They got you wired. So I couldn't say anything. And I spent so much time thinking about everything. So when I was at trial, I was like, I'm getting up there. When he asked me, Wolab asked me that part of the trial, he's like, are you going to testify? He asked me if I discussed whether I was going to testify with my lawyers or not. I had not, but I knew they didn't want me to. I just knew that. And I'm like, Matt, just do it. It was like, I was going to decide at trial, like, if I thought I was doing good or not. And I was like, it would be like a Hail Mary type thing if I was going to get up there and testify. I felt comfortable enough at that point, just being like, you know what, if you get up there, you probably fuck everything up. So just. I was
going to say that's the best decision you've ever made, my friend. To be quite honest, and no offense, I think anyone in that situation, that's the best decision.
They're just going to try to manipulate things, and you just don't know. When you're in jail, it's a horrible place. Mighty Meats talked about it. I spent 15 months there. Yeah. You don't know what's real and isn't real anymore. You don't know. I didn't know. I saw. You read my book, and I go into it in detail how weird it was. It was so. I mean, I wasn't thinking straight. So yeah, that was probably the best thing I ever did.
Emily, Stage Suicide in Ohio, a book that's got no numbers, but it doesn't matter. Yeah. You don't need numbers on it. Because Matt, you can't even spell couch. So
right.
It's the story of Emily and our relationship, and that night it goes into detail, and it's as much as I could. It's my story, it's just telling my story.
So I think next week, well, I've not spoken to you yet, but probably next Thursday, is Mighty Meat available next Thursday? That's the question. Put you on the spot.
I don't know.
He will be available. He's got nothing on, but I'm joking. But no, so next week it won't be like next Thursday, 11 o'clock your time, Matt, 2 o'clock Eastern.
All right, 11 o'clock, great.
We'll do that again.
I'm gonna open up my finances to everybody.
That's what I mean.
That's what I'm going to do. I'm going to let everybody know about the money. I think people are interested in what this would do to you if this happened to you. If you got some money in the bank, and why it happened to me. My view on my lawyers, my view on government, my view on why this happened the way it did. I don't think I really ever came across or had a chance really to explain to everybody why this happens. It's hard. It's hard to do in this format. So
no, I didn't want that. We wanted to the end. Otherwise, it's just too much.
Yeah, I completely understood. I'm gonna let you know what happened and why it happened and what to look out for. Just try to take my story and make some use of it. It's not exactly the way everybody thinks it is. You know what I mean? So
well, I think everyone knows that. I mean, you've alluded to it a few times. Do you know what I mean? So I think there's a few things that people might be a little bit shocked with. But no, that's fine. We'll do that. But before we do all that, to start next week, we will be also showing you the verdict. So if you don't know what the verdict is, don't go Googling anything. Don't spoil it. We'll show you the full verdict next Thursday at 2 o'clock Eastern to see what it is. Hopefully you can join us, Mighty, even if it's a bit later. But we're trying to do this. Yeah, I mean, I'm not sure how long it's going to be with Matt. It might be couple of hours, whatever it is, however long.
It shouldn't be. It shouldn't be. I'm just gonna badmouth some people, just kind of.
Well, like you've done throughout,
Hey,
really. So.
just a little tidbit.
I'll be there then
for Grubbs, because I hope Grubbs watches these and listens to these. What he did prior to being a Westerville detective is he worked for the city of Columbus, which is just out. Westerville is a suburb of Columbus, so he worked for the city cops for a while before he got hired by Westerville. And what he did is he worked on a task force that sexual predators online. What this dude did is sit in a cubicle, and he would talk, entice sick fucks, right? I mean, whatever they do, they talk dirty to. They talk dirty to pedophiles, and then they go and meet them somewhere and they arrest them, which is basically entrapment, or they create crime. That's creating crime, right? And basically that's what he did when he went to Westerville too. Is he just created crime? That's what they do. They create crime. They don't have anything else to do. That's what they do. I'm not saying anything for pedophiles. Obviously, there's a problem, but literally that is the definition of entrapment. And imagine if you're a cop. Would that be the division you want to be in? You know what I mean? Sitting around dealing with all that nonsense. I just wanted to let you know that Grubb is a scumbag. He's a real dirtbag.
That's fine. Well, you can go into it more like next week, man. So we'll go through it next week. So
you guys,
thanks,
I'm
buddy,
out.
for that.
Next week.
See you later, Matt.
All right.
Ta-ra, buddy.
Take care, man.
We got Dr. Smock.
Later.
Dr. Smock 2024 Hero of the Year Award by Mighty Meat.
Hell yeah.
Gave him that. Right.
Add to his CV.
I think Matt is going. I'll just kick him out. Yeah, no, that's fine. Well, what have you got on, brother? Anything going on? Are you busy?
Not really. Usually. Yeah.
Usually. No, I know. It's been a long day today. I'm even looking at the clock. What time did I even start today? I don't even remember. But yeah, Karen Reed seems to be intriguing, seems to be good. I'm hoping to do a stream maybe next weekend. I was going to get you on to do the Karen Reed, try and get a couple of people on that are sort of following it to see your thoughts. So I'm talking to you now like we're not live, it's like we normally talk about like we're live now. We go, yeah, so but no, I'll do something. I'll get in touch with you about that. Be nice to hear your thoughts as well on the case, because I know you send me following it, so right, okay, mate. Everybody, thank you very much for your time. Thank you for watching. Really appreciate you. Back with Karen Reed tomorrow morning. 8:15 a.m. Eastern, or if you're from the UK, 1:15 p.m. So yeah, and you heard from Matt. He's obviously going to be opening the books next week. How much he's been spending, his thoughts on Diane, his thoughts on the process, his thoughts on everything really. So, so yeah, with that, guys, thank you very much. Love it as always. So yeah, hopefully see most of you tomorrow with Karen Reed as well. Now I'm trying to find the fucking outro, but I can't fucking find it. Yeah, we are. I got it. Right, with that, everybody, take care of yourself. Peace.
That's